Madhura ma'am, we are ready now.
Thank you, sir. Tarush, good to go.
Okay. Ma'am, shall we begin?
Yeah, please.
Yeah. Good morning to one and all present here. Myself, Tarush Bhandari, and my co-host Nitya Singh takes immense pleasure to welcome you all for the national webinar on Consumer Protection Act 2019, organized by Navratna University, Vadodara, in collaboration with National Law School of India, University, Bangalore. Every year, 24th December is celebrated as Consumer Day to mark the historic milestone of enacting the first ever law for consumer protection in the year 1986. On the eve of the upcoming Consumer Day on 24th December, we have organized this national webinar to discuss the issues and challenges to the new Consumer Protection Act. We are delighted to have with us Honorable Justice R.K. Agrawal, President of the National Consumer Redressal Forum, Dr. Ashok Patil, Sir, Chair Professor of Chair on Consumer Law and Practice at NLSIU Bangalore, Dr. Nilay Yagnik, Sir, the Provost of Navratna University, Dr. Hitesh Bhatia, Sir, Associate Dean of School of Business, and Dr. Sujata Patil, Ma'am, the Principal of Law Program at Navratna University, along with several deans, principals, professors, students from esteemed institutes and professionals across the country with us today. I extend a warm welcome to you all. I invite Dr. Sujata Patil, Ma'am, Principal of Law Program, to give a welcome address.
Thank you, Tarush. I hope I'm audible.
Yes,
Yeah.
yes.
Yes, ma'am,
Yes,
you are
yes,
audible.
yes. Thank you, Tarush. Good morning to one and all who all present over here. Right. We were waiting since from long time for the day, and today we are all gathered over here. First and the foremost, I take this opportunity to welcome all the distinguished guests, speakers, and all the participants. And coming to the, if you look at the theme of the today's webinar, it I think based on the kind of participant and the kind of response that we received for this today event, really it is beyond our expectation. uh, I think if I go back, this is the event. It is not just planned 1 week or 10 days back. I hope, if I'm not wrong, Ashok Patil sir is aware about that. I think in the month of October, we thought of discussing. Let us have this awareness on the recent changes what we come across in the consumer law. And when we had a plan to organize this event in the month of, I think 'cause we started in the month of discussing October and November, we thought of having it. But due to, I think Ashok Patil sir was preoccupied with couple of sessions, then we thought of having it is ideal to have in the month of December. And even we too thought, based on our calendar, I think semester exams, everything get over. And we thought, let us have this day. And today we are celebrating. And coming to the kind of the response, really, we never expected, and happy to share that the credit goes to each and everyone. And when I think after the amendment of the Consumer Protection Act, I think pertaining to this theme, Professor Patil was doing, Ashok Patil sir was doing a tremendous job, and he started creating an awareness in the respective different colleges through webinar, seminar, and one of the event which I attended, and I thought, why this awareness? It should not constrain only to the state of Karnataka. Let the people in Gujarat, in the other rest of the other states, let them aware about it. In this connection, I put forth the request, and Ashok Patil sir agreed to with us to join with us in organizing this today's event. Really, if you look at the kind of the participant who are joined for the today's, it is across the country from Chennai, Andhra Pradesh, Rajasthan, Bhopal, Gujarat. Amazing to see. I think nearly 400 participants have registered as of now. This is happy to share with all of you. With this happy note, I take this opportunity to welcome distinguished guests, the distinguished speakers, and all the participants of the today's function. It's my pleasure to welcome the today's chief guest, Honorable Justice R.K. Agarwal. Presently is the president of National Consumer Dispute Redressal Commission, New Delhi, and the former judge of Supreme Court of India. Welcome you, sir, for the today's function. And I take this opportunity to welcome our Vice Chancellor of our university, Dr. Nilay Yagnik, the Provost, Navratna University. Welcome you, sir, for the today's function. Sorry, he'll join within 5 minutes. And I take this opportunity, a man who is behind us and he is always supporting and guiding. And at the same time, he accepted our request. And today he joined with us in organizing this today event. That is none other than Dr. Ashok R. Patil, a professor and the chair of consumer law and practice at National Law School, Bangalore. Welcome you, sir, for the today's function. I take this opportunity to welcome professionally a medical doctor and presently a member of National Consumer Dispute Redressal Commission, Dr. S.M. Kantikar. Welcome you, sir, for the today's function. And I take this opportunity to welcome a renowned and a very senior advocate, and he is also associated as a legal advisor with our Navrachna Educational Institutions, Advocate Jaideep Verma, a founder of Jaideep Verma Associates Vadodara. Welcome you for the today's function. I take this opportunity to welcome Dr. Pratima Narayan. She's an advocate and also a co-founder of the law firm in Bangalore. And Madam, she did her PhD in the area of, I think, if I'm not wrong, e-commerce and the consumer protection law from National Law School, Bangalore. I welcome, even she's also going to join after 1 hour. And welcome you, madam, for the today's event. I take this opportunity to welcome the registrar of our university, Mr. Rajesh Talati, and also take this opportunity to welcome Dr. Ritesh Bhatia, head of School of Business and Law, Navrachna University, and all my faculty colleagues, my dear students, invited friends, and also the participants from across the country. And if you look at the good in number of participants, see, one thing what I want to share on this platform, it may be a webinar or a seminar, conference. See, all these platforms is nothing but just sharing and gaining the knowledge. And what do we expect is good in number of participants, and they should get benefited out of it. And if you look at the crowd, really, I was surprised to see this across the country, the part of the today's event, and they're participating in this event. And what I thought, if you look at the crowd, there are three factors I feel that. One is maybe the theme of the today's seminar is very much generalized subject, which connect to each and every individual rights, because we all are consumer in one or the other way, and it relates to, it is not just constrained to the law student or law professionals. The theme is open to everyone. That is one factor I feel. And the second one, what I feel that it may be because of distinguished guest, the speaker, who are going to throw a light on different interesting, quite interesting and informative topics. Maybe that is one of the factor wherein there is a very good response. And the third part, what I can say that organizing this event in association is one of the prestigious institution in India, National Law School, Bangalore. Whatever the factors it may be, what I feel that really we are all happy. And the credit goes to each and everyone who are the part of organizing this today event. Thank you. With this note, I wish all the best for all the technical session. I once again welcome all of you. I hope and I definitely believe that this session is going to be a quite interesting and also informative, and each and every participants are going to gain out of it. Thank you one and all. And I thank organizing committee for giving me this opportunity to share few words.
Thank you, ma'am. We are blessed to have with us Honorable Justice R.K. Agarwal as the chief guest of this event. Honorable Mr. Justice Rajesh Kumar Agarwal was an advocate. He joined as an advocate on 14th August 1976 with his father, Sri Rajaram Agarwal, in Uttar Pradesh. He has worked as the standing counsel of the Income Tax Department of Government of India. He was elected as the permanent judge of the Allahabad High Court in 1999, and he assumed the office of the active Chief Justice High Court of Madras on 7th in 2013. He assumed the office of Chief Justice High Court of Madras on 24th October 2013. Then he was appointed as a as a judge of Supreme Court of India in 2014, and he retired in 2018. Currently, he is appointed as president of the National Consumer Disputes Redressal Commission as of 2018 after the retirement from the Supreme Court of India. Sir, it is an honor to have you with us. The stage is all yours, sir.
Yes, dear friends, a very good morning to all of you. I am extremely delighted to be associated and be part of the national webinar on Consumer Protection Act 2019 New Challenges, being jointly conducted by the Law Department of School of Business and Law, Narashna University, Vadodara, and National Law School of India University, Bangalore. With the growth of internet and advent of a global economy, the world has become one big marketplace, and all of us, irrespective of who or where we are, have become consumers, buying goods or services. A consumer is one who assumes to be treated like a king as they bring business to the seller. The, our father of nation, Mahatma Gandhi, having realized the important role of the consumers in the development of an economy of the country, has remarked that customers should be treated with respect as is precious and done a favor on the seller by coming to him for buying things. In a speech delivered in South Africa in the year 1890, he said, I quote, customers are the most important visitor on our premises. They are not dependent on us. We are dependent on them. They are not an interruption in our work. They are the purpose of it. They are not outsiders in our business. They are part of it. We are not doing them a favor by serving them. They are doing us a favor by giving us an opportunity to do so. Unquote. But the reality is that a considerable number of consumers are exploited in many ways by the business organizations by sale of unsafe products, adulteration and hoarding of goods, using wrong weights and measures, charging excessive prices, misleading advertisement, and sale of inferior quality of goods, deficient services, etc. As such, consumers are required to be protected against such exploitation. A consumer right is the hallmark of consumer protection law. There is an inequality of bargaining power between the consumer and the producer, which leads to the exploitation of the consumer. Consumer protection covers the right and privileges of consumers and how these rights should be accorded to them. It also deals with several issues relating to the welfare of the consumer and is also concerned with raising the standard of living in terms of improving the political and social well-being of consumers. The major aim of consumer protection law is to empower the consumers so as to enable him to enjoy these rights. After independence, a number of laws such as the Prevention of Food Adulteration Act 1954, Drugs Control Act 1950, Essential Commodities Act 1955, Monopolies and Restrictive Trade Practices Act 1969, and Bureau of Indian Standard Act 1986 were enacted for protection of consumer rights and interests. The origin of the consumer movement as it is today can be attributed to John F. Kennedy, the President of the United States, who equated the rights of the common American consumer with the national interests of the country. On 15th March 1962, he made a historic declaration of the basic consumer rights, that is, first, the right to safety, second, the right to information, third, the right to choice, and fourth, the right to representation. All these rights finally made their way to United Nations in the year 1985, and following the guidelines of the United Nations, our parliament enacted the Consumer Protection Act in the year 1986, for short, the 1986 Act, to provide a mechanism for cheaper and speedy redressal of the grievances of the consumers. The 1986 Act sought to promote and protect the right of the consumers against marketing of goods and availing of services which are hazardous to life and property. It also provided for right to be informed about the quality, quantity, potency, purity, standard, prices of the goods, and unfair trade practices of the manufacturers and service providers. The basic objective of enacting the Consumer Protection Act 1986 was to balance the power equation between the poor consumers and the powerful business merchants. However, the consumer market for goods and services have undergone drastic transformation since the enactment of the 1986 Act. The modern marketplace contains a plethora of products and services. The digital age has ushered in a new era of commerce and digital branding, as well as a new set of customer expectations. Digitization has provided easy access to a large variety of choice, convenient payment mechanism, improved services, and shopping as per convenience. But along the growth path, it also brought in challenges related to consumer protection as the consumers are still victims of unscrupulous and exploitative practices. Exploitation of consumers assume numerous forms such as adulteration of food, spurious drugs, high prices, poor quality, deficient services, deceptive advertisement, hazardous products, and many more due to globalization and international trade, which has offered new goods in the field of insurance, transport, electricity, housing, entertainment, finance, banking, e-commerce, etc. As new situations and issue arises, the law has to be evolved in order to meet the challenges of such new situations. Law cannot afford to remain static. We have to forge new tools, evolve new principles, and lay down new norms which adequately deal with new situations which arise daily in highly industrialized economy. It is high time that in the present more consumer-oriented market, the old rule of caveat emptor, let the buyer beware, must give way to the rule of caveat venditor, seller be aware. Caveat emptor has been part of common law since the 17th century. Under this, liability accrues to a seller only when the defect cannot be detected by sight and is a matter of skill or collateral proof, and the buyer is not to be ignorant of the amount and nature of the interest which he is about to buy. However, caveat venditor defines the maxim as if the seller wishes to secure himself from future responsibility in case the article sold should afterwards be found to be different in kind or quality from what the party supposed it to be. He must take care or provide against such responsibility by a particular agreement with the purchaser. Under this maxim, the seller has greater responsibility to ensure the quality and nature of goods and service procured by the buyer. This apart, there are a plethora of cases pending before the consumer fora, and because of considerable delay in disposal of cases by the redressal agencies, despite a disposal rate of about 90% of the complaints, the 1986 Act has failed to meet the expectations of the consumers and to achieve the objectives for which it was enacted. Speedy disposal of cases is an important issue for all concerned as delay in justice is denial of justice. Therefore, it became inevitable to amend the Act to address the myriad and constantly emerging vulnerabilities of the consumers. Bearing this in mind and to address the new set of challenges faced by the consumers in the digital age, the Consumer Protection Act 2019 has come into existence and was enforced from 20th and 24th July 2020. Keeping pace with changing times and new legislations aimed at protecting the interests and mass, the 2019 Act has successfully broadened the scope of various provisions, including persons who can file a consumer complaint, as also include class actions. Some of the salient features of the 2019 Act are: while the 1986 Act was facing various difficulties with its implementation on various teleshopping and online transactions, the 2019 Act has removed any muddle on its applicability in similar circumstances. The scope of the application of the consumer law has been enhanced by the 2019 Act by modifying the definition of the consumer. Explanation B to subsection 7 of section 2 of the 2019 Act states that the expression buys any goods and hires or avails any services includes offline or online transactions through electronic means or by teleshopping or direct selling or multi-level marketing. Further, to address emergence of global supply chains, rapid development of e-commerce, and to tackle misleading advertisements, telemarketing, multi-level marketing, and direct selling, the 2019 Act has attempted to define e-commerce. Subsection 16 of Section 2 of the 2019 Act contemplates that e-commerce means buying or selling of goods or services, including digital products, over digital or electronic network. Subsection 17 of Section 2 deals defines electric service provider to mean a person who provides technologies or processes to enable a product seller to engage in advertising or selling goods or services to a consumer, and includes any online marketplace or online auction sites. The 2019 Act also empowers the center to make rules for preventing unfair trade practices in online trade. The term deficiency has also been redefined. Subsection 11 of Section 2 of the 2019 Act, the deficiency has been defined to include any act of negligence or omission or commission by such person which causes loss or injury to the consumer and deliberate withholding or relevant information by such person to the consumers. The 2019 Act contains several provisions for simplifying the consumer dispute redressal process. Some of them are that the upper limit of pecuniary jurisdiction of the district forum, the state commission, and the national commission has been increased from the existing rupees 20 lakhs, rupees 1 crore, and above rupees 1 crore to rupees 1 crore, rupees 10 crore, and above rupees 10 crore respectively. The increase in the pecuniary jurisdiction of all the three forums is an encouraging step as it will attract lesser number of claims in appellate commissions to an extent, thereby ensuring swifter disposal of cases. Further, the term pecuniary jurisdiction has been defined in the new Act as where the value of the goods and services paid as consideration as against the earlier term where the value of goods or services and compensation of any claim. Therefore, the compensation claimed by the complainant does not seem a factor in assessment of jurisdiction, but the phrase paid as consideration seems to imply that the pecuniary jurisdiction is determined by what has actually paid already by the complainant and not the total value of the goods or services. Now, under sections 40, 50, and 60 of the 2019 Act, the District Forum, the State Commission, and the National Commission respectively have the powers to review any of its order if there is an error on the face of the record, either of its own motion or an application made by any parties within 30 days of the date of the order. Friends, I may make it clear that even under the 1986 Act, the National Commission has been given the power to review. Friends, to grant further relief to the consumers, the 2019 Act has included under subsection under clause D of subsection 2 of section 34, the place of residence of the complainant and place where the complainant personally works for gain for determining the territorial jurisdiction of the commission, thereby making it a wider and an easier approach. A complaint can now be filed electronically, and section 36 of the Act 2019 Act provides as under. Provided further that the admissibility of the complaint shall ordinarily be decided within 21 days from the date on which the complaint was filed. And further, where the district commission does not decide the issue of admissibility of the complaint within the period so specified, it shall be deemed to have been admitted. Thus, it makes it very clear that if the consumer forums do not decide the fresh complaints within 21 days from the date which has been filed, then it will stand admitted, and no order of admission is required to be passed. The 1986 Act indeed has failed to provide a regulator to enforce the consumer rights. Keeping in mind this provision has been made in the 2019 Act for establishment of a national level regulator called the Central Consumer Protection Authority, which in short I may say CCPA, which will be headed by a chief commissioner and comprise other commissioners. Section 10 of the 2019 Act provides as under. The central government shall by notification establish with effect from such date as it by in this notification a Central Consumer Protection Authority to be known as the Central Authority to regulate matters relating to justice, unfair trade practices, and false or misleading advertisements which are prejudicial to the interests of public and consumers, and to promote, protect, and enforce the rights of the consumers as a class. Friends, CCPA will have an investigation arm headed by a Director General for the purpose of conducting inquiry or investigation under the Act. It has to deal with rights of consumers as a class. It has also the power of search and seizure in the matters which are prejudicial to the interest of the public and the consumers. In addition to regulatory functions, the authority is vested with suo motu power also to inquire into any violations of consumer rights. It may also issue safety notices, pass orders to recall goods, prevent unfair and restrictive trade practices, reimburse purchase price paid, and impose penalties for false and misleading advertisement. The CCPA may also file complaints before the Consumer Dispute Redressal Commission. It has been vested with the right to impose stringent penalties for offences of misleading advertisements, manufacturing, selling, storing, distributing, or importing adulterated or spurious products. Under Section 24 of the 2019 Act, a person aggrieved by any order passed by the CCPA under Section 20 and 21 may file an appeal to the National Commission within a period of 30 days from the date of receipt of such order. A new concept of product liability has been introduced in Chapter 6 by the 2019 Act, which was in dire need of Subsection 34 of Section 2 of the 2019 Act defines product liability to mean the responsibility of a product manufacturer or product seller of any product or service to compensate for any harm caused to a consumer by such defective product manufactured or sold or by deficiency in services relating thereto. Section 82 to 87 of the 2019 Act deals with the procedure of product liability. The Act permits a complainant to make a claim of product liability against a product manufacturer or a product service provider or even a product seller for any personal injury, illness, death, or property damages resulting from defects in manufacture, construction, design, formula, preparation, assembly, testing service, warning, instructions, marking, packing, labeling of any product, etc. The 2019 Act has gone a step forward and defined a product manufacturer, product seller, and product service provider to provide clarity on who can be made liable for an action. Insertion of product liability is a separate chapter in the 2019 Act, and a new ground for filing a complaint has been one of the most significant additions to the new Act. The definition of the product liability has very effectively brought online and offline services within the ambit of the Consumer Protection Act. Online retail platforms can be made liable for the products available for sale on their websites. Now, unfair contract has also been added which further broadens the ground to file complaints and allows consumer to challenge contracts which are unfair, unilateral, and unreasonable. This is in line with the Honorable Supreme Court judgments where it has been held that courts will not enforce and will, when called upon to do so, strike down an unfair and unreasonable contract. This is especially useful in the light of the standard unilateral terms and conditions imposed upon the customers in various fields like housing, e-commerce, banking, etc. Subsection 46 of Section 2 of the 2019 Act defines unfair contract means a contract between a manufacturer or trader or service provider on one hand and a consumer on the other, having such terms which cause significant change in the rights of such consumer, including requiring manifestly excessive security deposits to be given by a consumer for the performance of contractual obligations or imposing any penalty on the consumer for the breach of contract thereof, which is wholly disproportionate to the loss occurred due to such breach to the other party to the contract, or refusing to accept early repayment of debts on payment of applicable penalty, or entitling a party to the contract to terminate such contract unilaterally without reasonable cause, or permitting or has the effect of permitting one party to assign the contract to the detriment of the other party who is a consumer without his consent, or imposing on the consumer any unreasonable charge, obligation, or condition which puts such consumer to disadvantage. From this definition, which has been added in the new Act of 2019, one thing is very clear, that the small type conditions which may adversely affect the purchasers or the recipients of the service, or in broader term we may call consumers, have a right to challenge the same before the consumer fora, and the consumer fora will not feel shy of declaring those terms of the contract as unfair and striking it down, thus relieving the consumer from the liability of such terms and conditions. To meet the objective providing speedy, inexpensive justice, especially to small consumers, as observed by the Supreme Court in Catena of Judgments, a new Chapter 5 on mediation as an alternative dispute redressal mechanism has been inserted in the 2019 Act. The new Act contemplates the attachment of the consumer to the consumer fora a mediation cell and reference thereto of any complaint upon its admission if it appears to the concerned fora that there exist elements of a possible settlement between the disputing parties in the complaint. Subsection 25 of Section 2 of the 2019 Act provides that mediation means the process by which a mediator mediates the consumer disputes. With regard to the reference of consumer dispute to mediation, Section 37 provides that at the first hearing of the complaint, after its admission, or at any later stage, if it appears to the fora that there exist elements of a settlement which may be acceptable to the parties, except in such cases as may be prescribed, it may direct the parties to give in writing within 5 days consent to have their disputes settled by mediation in accordance with the provisions of Chapter 5. Where the parties agree for settlement by mediation, the mediator may direct the parties to give in writing within 5 days consent to have their disputes settled by mediation in accordance with the provisions of Chapter 5. Sections 21 of the 2019 Act deal with the establishment and composition of consumer mediation cell, procedure of implementation of mediations in the mediation cell, and settlement through mediation. Further, Section 81 of the 2019 Act prescribes the procedure to pass suitable order for recording such entitled settlement. The 2019 Act has further provided the definition of misleading advertisement. Subsection 28 of Section 2 of the 2019 Act defines misleading advertisement in relation to any product or service means an advertisement which falsely describes such product or service or gives a false guarantee to or is likely to mislead the consumers as to the nature, substance, quantity, or quality of such products or service, or conveys an express or implied representation which, if made by the manufacturer or seller or service provider thereof, would constitute an unfair trade practice or deliberately conceal important information. The CCPA may impose a penalty of up to rupees 10 lakhs on a manufacturer or an endorser for a false or misleading advertisement. Now, the endorser has to be very careful and cautious while endorsing any products, because if subsequently it turns out to be false, then the endorser, whether he's a film artist or a hero or anybody else, he will be liable to give pay penalty of up to rupees 10 lakhs. The CCPA may also sentence them to imprisonment for up to 2 years for the same. In case of subsequent offence, the fine may extend to rupees 50 lakhs and imprisonment up to 5 years. The CCP can also prohibit the endorser of a misleading advertisement from endorsing that particular product or service for a period of up to 1 year. For every subsequent offence, the period of prohibition may extend to 3 years. The 2019 Act has also sought to increase the culpability of the offences that may be committed against the consumers and have made the penal provisions more severe and deterrent for non-compliance of the interim orders. It has attempted to bring the Consumer Protection Act under the ambit of criminal jurisprudence. Section 17 of the 2019 Act states that every order made by a district commission, state commission, or the national commission shall be enforced by it in the same manner as if it was a decree made by a court in a suit before it, and the provisions of Order 21 of the first schedule to the Code of the Civil Procedure 1908 shall, as far as may be applicable, subject to the modification, that every reference thereon to a decree shall be construed as reference to the order made under this Act. Subsection 1 of Section 72 further provides that whoever fails to comply with any order made by the District Commission or the State Commission or the National Commission, as the case may be, shall be punishable with imprisonment for a term which shall not be less than 1 month, but which may extend to 3 years, or with fine which shall not be less than 25,000 rupees, but which may extend to 1 lakh rupees, or with both. Friends, the net effect of the 2019 Act, in my humble perception, is that it is more in tune with the modern day concepts of consumer protection, new market dynamics, and developments in the digital age. It deals with unfair contracts and e-commerce issues. It provides for e-filing of complaints and product liability suits. It also provides for mediation in addition to the earlier system of consumer justice and empowers the Central Consumer Protection Authority or the regulator to recall unsafe goods or services under reimbursement of their price, put a stop to unfair trade practices, including false and misleading advertisements, orders, investigation into violation of consumer rights, and in general, promote, protect, and enforce the rights of consumers as a class. Last but not the least, the new changes that have been made in the 2019 Act will definitely ensure a safer and fairer market for the consumers to interact with the providers, but to what extent only time will tell. Friends, even under the new Act, that is the 2019 Act, the consumers or any party has not been given any right of appeal, second appeal, or revision in an order passed in execution proceedings. As held by the Honorable Supreme Court in the famous case arising from Karnataka, a revision is not maintainable in against an order passed in appeal arising out of consumer execution proceedings because the complaint is not pending. The same position still continues. Secondly, recently the Honorable Supreme Court in one of its decisions has held that if an Consumer Fora has passed an order under Section 71, which was earlier akin to Section 25 of the Act, 1986 Act, an appeal to the Honorable Supreme Court or before any forum does not lie. These two things which the Parliament ought to have taken into consideration has not been done, and therefore, if an order has been passed and appealed by the appellate authority in execution proceedings, then the remedy under the Consumer Protection 2019 is not available. However, one good thing which has the new act has done is that a second appeal has been provided before the National Commission on substantial question of law, which is akin to Section 100 of the Code of Civil Procedure. This is a new right which has been given to any person aggrieved by an order passed in first appeal by the State Commission. So let us see how the new act works. It will all depend upon your cooperation and understanding and assisting the forums. Thank you very much.
On behalf of Navrachna University and NLSIU Bangalore, I extend my sincere vote of thanks to Justice R.K. Agarwal sir for spending his precious time and gracing us on this occasion. Your thoughts have enlightened our minds. Thank you for your words of wisdom, sir.
Thank you very much.
Yes.
Honorable Justice Agarwal, sir. My name is Dr. Nilay Yagnik. I'm the Provost of Navrachna University. On behalf of the entire university, I thank you, sir, for enlightening us today and spending so much of your valuable time with us. Thank you, sir.
Yes. Justice sir, this is Dr. Patil. Thank you
Yes.
very much for your insightful presentation. And right now our provost has joined. Dr. Nilay Yagnik is our Vice Chancellor of our university. And thank you for your wonderful speech.
Now, I would like to welcome Dr. Nilay Yagnik sir, who is the Provost of Navrachna University. Dr. Nilay sir has done his instrumentation engineering from BITS Pilani and a master's from Narsi Munji Institute of Management Studies, Mumbai, and PhD from University of Mumbai. He has over 13 years of experience in the IT industries and over 27 years of teaching experience. He has a lot of academic leadership experiences with him. He has also many national and international publications to his name. He is also an alumni of Harvard Business School of Global Colloquium and participant of Centered Learning held in Boston, USA. Thank you, sir, for joining with us. We would like to, I would like you to grace this occasion with your words of wisdom.
Thank you. And on behalf of Navrachna University, I welcome all of you to our national seminar on the Consumer Protection Act. I wish to congratulate, of course, our team of the School of Law, Dr. Sujata Patil and Dr. Hitesh Bhatia, who heads the School of Business also. And It is indeed a wonderful experience today to be able to talk to all of you on this Consumer Protection Act. Though I don't know much about Consumer Protection Act, and I too am interested in learning more about it. But one thing I can mention is that even in 2019, when this new amendment to the Act came up, it brought some extremely relevant aspects of the new economy, and which is the aspect of e-commerce. Till then, e-commerce was kind of untouched from the Consumer Protection Act as such. But now, with the 2019 amendment, the e-commerce has also come into the fold of the Consumer Protection Act. And I must say, it was such a far-reaching amendment. It was such a far-reaching thought on the people who designed this particular act, because none of us knew in 2019 what was to happen soon after. And it became extremely useful. And the act was so relevant, especially after March 2020, when the lockdown happened and more business started happening on e-commerce. There was an exponential increase in e-commerce transactions, which in turn led to several aspects and several issues. But the consumer felt protected because of this particular act. It's extremely relevant for everyone, whether it's a consumer like you or me, or whether it's even an institution like us. For example, if we order as an institution, we are a consumer, we buy several books for our library, and we read, we may decide, like us, others also, institutions, may decide to route the purchase of books for our library through, let us say, an e-commerce provider, a very large e-commerce, multinational kind of an e-commerce provider. Many of these e-commerce providers are huge multinationals. And we order, lakhs worth of books. And when the boxes come, we find the books which we ordered are not there. Worse still, it is not what we ordered. It is something else. It is not books. It is some other product that has come inside. So, an institution like ours, where do we go? We are here to teach our students. We are here to learn and teach and kind of create knowledge as well. Where do we go, right? If you approach the e-commerce provider, he would say, oh, I did what was ordered. If you approach, he would say, approach the book vendor. We approach the book vendor. He says, I don't know. I've gone exactly as per the order. We approach the distributor. He also says the same thing. Courier company says the same thing. Where do we go, right? So this was the problem. But today, hopefully with this new amendment, we should be able to take certain corrective steps. And like us, the consumer, an average consumer like you and me, we too, when we order something, we should get what we order for, and we should get it in the particular time. And that is why I think the Consumer Protection Act amendment of 2019 is so relevant for all of us in the society today. Another aspect is the aspect of filing a complaint electronically. That has kind of facilitated the whole thing. So as a consumer, I can file my complaint to the forum, and it would be heard also, even though it's an electronic complaint. Not only that, the hearing can also happen on video conference. So especially during lockdown kind of situations, or situations like today where you don't like to really go anywhere, you like to operate from here, then this becomes extremely relevant. So I think, it's an extremely relevant topic, the Consumer Protection Act, which the School of Business and Law, Dr. Hitesh Bhatia, Dr. Sujata Patil, and the entire team of law, School of Law has taken up today. I also wish to thank the National Law School of India, Bangalore, for collaborating with us today for organizing this seminar. And my special thanks to Dr. Ashok Patil. He is also here attending today. He's a speaker here today. and from the National Law School of India in Bangalore. And it is really a wonderful experience to be able to collaborate with India's top law school. So thank you very much, Dr. Ashok Patil and the National Law School of India for collaborating with us for this particular seminar. I wish to also thank so many speakers, eminent speakers who will be enlightening us today, like Advocate Jaideep Verma, like Dr. S.M. Kantikar, like Madam Pratima Men. So, we will get a whole bunch of ideas today and a whole spectrum of ideas and possible solutions also on how we can address these as a consumer. I always feel that the field of law has actually been ahead in many ways. In fact, the concept of a case study, which we always use in the School of Business, all business schools all over India, case studies actually came from law. So the business school case study, or the concept of discussing a case study, came from actually the field of law. So law, I always believe, can be, should be, and is many times ahead of many other disciplines. And here we see one area where the discipline of law has taken such a step forward in the Consumer Protection Act of 2019 by including e-commerce in the entire transaction, in the entire scenario. So thank you very much once again for inviting me also to speak for a few minutes and give my thoughts. Thank you, and I wish the seminar all success today. Thank you.
Okay. Thank you. Thank you, sir. Thank you.
It is very fortunate and honor to be mentored by you as a provost. You have been a constant support and you have given a lot of encouragement, sir. Thank you, sir, for the constant support and your encouragement.
Thank you.
Now I would like to welcome Dr. Ashok Patil, sir, who is a professor of law at NLSIU Bangalore and chair of consumer law and practice. Sir, we would like and request you to throw a light and give an introduction to the topic for the today's seminar.
Thank you very much. So, as Sujata told at the beginning, we planned 2 months back, and ultimately, successfully, we started today with all the great speakers and Justice R.K. Agarwal. And when we planned, we wanted to give complete comprehensive view of the legislation, new legislation, because many of the people thinking in a different way, a lot of confusions were there. So to clarify those things, we divided these webinar into different sessions, very important topics we have put, and we invited the subject experts on that particular subject. So in this particular today's webinar, before I start the technical session details, I thank Dr. Nilay Agni, who has spoke very well with his personal practical experience. That counts a lot in law. Law is on paper. If it is implemented, how it is effective. That is the very important thing we are discussing today. Thank you very much, sir, for excellent experience sharing with us. Today, next in first session, I'm taking that session. I'm giving you how this particular legislation enacted, because I was involved in the drafting of this legislation since 10 years. I'm heading consumer chair of Ministry of Consumer Affairs, Government of India since 2008. We started working on it, amending this legislation in 2010. So I will share all my experience, how we have developed and ultimately how we have enacted, and how much Ministry of Consumer Affairs, Government of India took strain, pain in bringing this particular legislation, taking all stakeholders' view and come out with the new legislation and rules, regulations. So that I will share in my first technical session. And technical session 2 is Mr. Jaideep Verma, sir, advocate, who is a senior advocate and experienced. He will discuss on consumer redressal system. We have a three-tier redressal system under Consumer Protection Act: District Commission, State Commission, National Commission, next Supreme Court. So how the cases are admitted, complaint is admitted, and what are the technical issues in procedure, and from 86 how it has changed in 2019. So all practical experience Mr. Jaideep Verma sir will share in his technical session 2. And the technical session 3 is by Honorable Dr. S.M. Kantikar, who is a member of NCDRC, and he is the first person who is a doctor, MBBS, MD, and becoming a member of a National Commission. Is a record, and not only that record, he reappointed for second term. It is very rare, but because of his skill and delivery of judgments considered, and second term is given to Justice Kantikar. And another very important thing, even after becoming a member of National Commission, he has not stopped his study. So in first term, he did first term of member as an NCDRC. He completed his PhD on medical negligence, consumer protection and medical negligence from National Law School. So he's an expert in that particular field, and he is handling presently all medical negligence cases which are before the National Commission. So he is dealing with liability of medical negligence under the CPA 2019. And technical fourth session is on e-commerce reforms in India. This is very important in the present situation at the national level as well as at the international level. And that is dealt by Dr. Pratima Narayan, advocate. She is also expert in this because she also did a PhD on e-commerce, consumer protection and e-commerce in National Law School of India University. And she is handling a lot of these issues in day-to-day practice. So that's why we selected her for this particular session. And she is dealing with e-commerce. And under not only e-commerce definitions, other things are given under the Act. Separate rules are framed on e-commerce. In detail, she will discuss on that. So this is the roadmap of today's webinar. And I hope all the participants will enjoy all these technical sessions. And at the end of the webinar, everybody will get a comprehensive view of CPA 2019 so that the practitioners, they can adopt those things. And especially for students, it is very, very important. You should take this one very seriously, because to appear before the Consumer Commission, there is no need for becoming an advocate. Even as a student, you can appear before the Consumer Commission, District Commission. You can argue the matter on about your case also, and on behalf of others also. So you can get a practical experience even during students' life. When you complete the law degree, you will get all skills of how to addressing the judges, how to convince the judges, how to handle the opposite party, how to draft the complaint, how to appreciate the evidence. All these things, practical experience, you will learn during this 5 years as a student. So it will help you, especially for students. I'm telling this because in National Law School, our students, a lot of students have filed a consumer cases, and they themselves argued the matter, won the case also. And also they filed a PIL on consumer issues. So this will gain as an institution, as a university, as a faculty, as a student, you are giving or you are doing social service to the society by doing all these types of works. So that's why with this brief note, I'm concluding, and thank you very much for the co-host who agreed and came forward and organizing it very effectively. Thank you very much, one and all. Thank you.
Thank you, sir, for shedding a light on the topic of the discussion for today's webinar. We would be starting the technical session shortly, so kindly stay tuned.
Thank you.
Navratna University has organized international virtual conference on interface between law and technology on 30th January 2021 with the knowledge partner as Center for Law and Technology, Gujarat National Law University. We would request all the dignitaries, the participants, and the teachers to kindly go through the brochure and submit their research papers for this international virtual conference and make this conference a success. For further more details, we would be attaching the brochure, or you can kindly write it in the chat box.
I hope Ashok Patil's.
Yes, ma'am, I'm here.
Sir,
Yes.
Ashok Patil, sir. Yeah, yeah, sir is ready. I hope we can start, sir.
Yeah.
Okay, okay. Tarush.
Just a minute, ma'am. So, good morning to one and all present. Now we are starting with the first technical session for today's webinar. The first technical session would be taken up by Dr. Ashok R. Patil, who is a professor of law at NLSIU Bangalore and chair of consumers and law practice. Sir has graduated and in BSc and did his LLB, LLM, and PhD from Karnataka University, Dharwad. He has published more than 8 articles in international journals and more than 42 articles in national journals. He has more than 6 books to his name. He has been organizing more than 41 training programs or workshops for non-governmental organizations, teachers, and government and private lawyers. He has received several awards and fellowships, such as Asian Law Institute's Fellowship in 2010 and National Award for Legal Education Innovation Award 2013, to name a few awards, and the list goes on. Sir has been the chief editor of many international and national journals, such as International Journal of Consumer Law and Practice, which is an annual journal, and the biannual magazine, March of Consumer Law and Practice. He has been the member of the drafting committee on Consumer Protection Bill 2019 and regulations under Consumer Protection Act 2019. He has also been the board members of international and national institutions. Sir, it is an honor to be hearing from you on such an interesting topic. The stage is all yours, sir.
Thank you very much for introduction. So let me share my PPT.
Okay.
Yeah. Now, can you see me, my PPT?
Yes, sir. Yes, we can see your slide.
Okay, right. Right. Thank you very much once again for this session. All the participants in this webinar, my sincere thanks to you for attending this particular technical session. And what is my plan? 45 minutes I will present on comprehensive or overview of the legislation. Then we'll keep 15 minutes for question and answer. If anybody is having questions, you can put questions in the chat box. And within 15 minutes, whatever questions are there, we'll answer. And in other sessions also, the other technical sessions, the resource persons will take those questions ahead and go in depth on that. So in this session, I'm giving you bird's eye view, not in detail on each subject or each topic. So just I'm giving you bird's eye view of this legislation. Majority of the things are discussed or dealt by Justice R.K. Agarwal, sir. He narrated all the changes, whatever happened. Here, I'm a little bit going in depth on those issues, whatever Justice discussed, with some explanation I'm presenting before you. So this is a statement, as Justice said, customer, gist of this particular statement is consumer is a king. But it should not be on paper. It should be implemented with spirit. Practically, it should happen. That is the aim of the Consumer Protection Act also. But things are not happening in that way. That's why, as a state, as a government, they are enacting laws, rules, regulations to protect the consumers. Yes, business, anybody can do business in India within the four walls of constitution, and whatever laws of the land is there, they should stick to those laws. And in India, whatever laws are enacted or whatever activities are happening, that is within the four walls of the constitution. And right to do business is a fundamental right narrated in Article 19(1)(g), right to freedom to carry on business and trade. But as you know, it's not an absolute fundamental right. State can impose reasonable restrictions on trade in the interest of public. So on that basis, this is the Article 19(6). On that basis, state government, central government, they are protecting the consumer. Another very, very important article is Article 21 of Constitution, right to life without exploitation. Right to life with dignity means without exploitation. It is the duty of the state to give guarantee to the every person in the country not to exploit by manufacturer or service provider, whosoever. So that is the duty of the state. And there are two directive principles of the Constitution. Article 38, state to secure a social order for the promotion of welfare of the people. And 47, duty of the state to raise the nutrition, raise the level of nutrition and the standard of living and to improve public health. Because of these articles, fundamental rights, let us start with the preamble, fundamental rights, directive principles. Together, it is the duty of the state to protect the consumer. In that angle, state has done its duty by enacting consumer welfare legislations and the regulatory authorities to protect the customers of that sector. One of the very important landmark judgment, Anita Kushwaha versus Pushap Sudan. So in this case, Supreme Court laid down that access to justice is a fundamental right. And to satisfy this access to justice, it has laid down four facets, main facets of the essence of access to justice. What are those 4 points to satisfy access to justice? First one is state must provide an effective adjudication mechanism. State, here state means the central government or state government. So state must provide an effective adjudicatory mechanism. Second one, the mechanism so provided must be reasonably accessible in terms of distance. Third one, the process of adjudication must be speedy. Third one, it should be speedy. And fourth one, that is the litigants' access to the adjudicatory process must be affordable. So all these 4 essential elements inculcated or tried to put it in CPA 2019 in one or the other way. Effective adjudicatory mechanism means whenever dispute comes, state must provide mechanism where it can be heard and give justice to the aggrieved consumers. Now, 3 forums are available. One is the Central Regulatory Authority. Second one is Consumer Redressal Commission. And third one, even before going to the commission, through mediation, it can be settled. So these are the 3 ways available to the aggrieved consumer. Again, to approach a regulatory authority, there are conditions. If it is unfair trade practice or misleading advertisement, and it is aggrieved as a class, consumer as a class, then you can file a complaint to the regulatory authority. So that's a one point. And second one, reasonably accessible in terms of distance. See, presently what is happening, if a Bangalore person, aggrieved consumer, wants to file an appeal from state commission to national commission, he has to go to Delhi and file a case. He has to hire an advocate, then he has to take that advocate to Delhi, stay for 1 or 2 days, file a case. Just filing a case, he has to spend all this amount, huge amount. That's why, and even in the state level, remote place, for example, in Karnataka, remote place, Bidar, Gulbarga person, aggrieved person, if he wants to file a case or appeal in Karnataka State Consumer Commission, he has to come to Bangalore and file it. Because of these technical and other economic issues, people are not filing the cases at all. Even though they are aggrieved, but they are not filing a case because of these issues. So those issues now under the CPA 2019 try to reduce through e-filing. If e-filing is recognized, then you can pay the fees online, video conferencing, all these things are recognized under the new legislation. Then third one, the process, another thing, in the second point itself, if all consumers are not technically sound, India is having a different culture. Every state is having its own culture, and the villages may not have that much technical facilities. But nowadays, the majority of the people, even in village, they have a smartphone. They are purchasing online. Even then, we cannot say that it is everybody is having that facility. In those cases, the under the Act itself, the central government has made under the Act, if state commission can sit in other places with the notification of state government. So Bangalore in Karnataka is the south of Karnataka. If they want to sit in Dharwad or Belgaum, then state government can notify, then the state commission can sit in the Dharwad or Belgaum of a remote place and hear those matters where it is from that area. Even branches can be open, benches can be open. Same way, National Commission also. National Commission can open, it's a bench in the Bangalore or any other place, so that southern people can the approach physically and present their case. So that facility is also made under the new legislation. Then coming to the process of adjudication must be speedy. Once everything happens or recognized online, automatically it will be speedy. So presently, in looking into the past, I will share two national surveys. One is the CUTS International Survey, as well as IIPA, Indian Institute of Public Administration Survey, where in the survey, we come to know how much we are going speed in physical administration of consumer redressal. So that is clearly shown. So within 3 months, even though legislation says the case has to be disposed of, consumer case has to be disposed of within 3 months from the date of the notice served to the opposite party. In case of lab test, it is a 5 months, but things are not happening in that way. So that's why all those things, whatever observed in those surveys, considered in the new legislation. So here, especially even in civil court as well as consumer commission, lot of time it takes to serve the notices. That itself takes time. So now electronic mode is recognized. Even through electronic mode, they can send the notice so that it can be reached quickly, and case taken it very quickly. So like that, a lot of measures have been taken in this legislation. Fourth point, the litigants' access to the adjudicatory process must be affordable. So if you compare to the the civil court, the court fee under the Consumer Protection Act is very, very negligible. And from 2018 notification of Ministry of Consumer Affairs, up to 5 lakh rupees, no court fee. Up to 5 lakh rupees, no court fee is given to the Consumer Commission to admit its case, hear that case. So it shows clearly the government, Ministry of Consumer Affairs, is very serious on achieving or satisfying all these 4 essential elements of the landmark judgment of Anita Kushwaha. So throughout the legislation, all these 4 points are kept in mind behind the screen and frame the rules, regulations, and the sections. So all these things we will see whenever, in next slides. all these things. And another very important of this legislation, why Consumer Protection Act is enacted when the civil courts are there. So as the Justice Agarwal said, first time these consumer rights recognized as a legal rights in US by John F. Kennedy. He introduced these rights, 4 rights in Congress. And later, international level lobby happened, and UN, United Nations, has came out with the guidelines, called UN Guidelines on Consumer Protection in 1985. And on that next year itself, India is the first country. We should be proud that the government of India enacted an independent legislation exclusively for consumers in 1986. So Consumer Protection Act 1986 on the basis of UN guidelines 1985. And this act, 86 Act, when it was drafted, what was the intent of the legislators? What is the object of the 1986 Act? Why this was enacted independently? Why not these cases added in the civil code? Objects are very, very precious. We know that in civil court, what is happening? In civil court, the delay in disposal of the cases, complicated procedure. Once CPC applicable, Civil Procedure Code, then it itself is a complicated one. So no layman can understand CPC and Evidence Act, and court fee is huge. As per what is your claim, on that basis you have to deposit the percentage of the court fee, and you have to hire the advocate because you cannot argue your case because of the complication. So all these things, it was there in civil code. Then, and even when in this 86 Act was enacted, they kept in mind whatever words used in the civil code, those words should not be used in the 1986 Act. So in civil code, plaintiff, defendant, written statement, judges, court. So these are the common words used in the civil code. These words are not used in the Consumer Protection Act, rules, regulation, kept in mind not to use. So it should be consumer friendly, consumer environment. So that is the object behind this legislation. And 2 times amended, and especially Consumer Protection Rules 1987 and Regulation 2005. So same things are adopted under the 2019 also. The Regulation 2005 is very, very important, how Consumer Commission should behave, act with the consumers. That is clearly given. Even their dress code, chairs, podium, everything is described in that particular regulation. Ultimately, what is the intention of the legislators is to help the needy consumer. That is the object. So because change in the trade, business, the things have changed. Now we have shifted offline to online trade. New types of things started. So to equip with the present trade business, how to protect the consumer. So that is the issue came before the Minister of Consumer Affairs. Then they started thinking on it. Since 2010, we started working on it. So they conducted many programs throughout India. Minister of Consumer Affairs conducted 4 regional conferences throughout India. Southern one we conducted in National Law School, how to amend the Consumer Protection Act. At the beginning, only plan was to amend the 86 Act. So in that angle, we worked many aspects, what are the loopholes of the 86 Act, and suggested the amendment. There were the bills, 2013, 14 bills were there. And in 2014, the new government came, and then the lot of amendments are there.
doing a lot of amendments in the existed act. So a lot of amendments. Can you hear me?
Yes, sir. We could hear.
Okay. So on that basis, the when BJP government came and the cabinet minister took it very serious, and they came out with the independent legislation, that is Consumer Protection Bill 2015, and it was introduced in the Lok Sabha, and Lok Sabha referred it to the standing committee, and standing committee was around 20, more than 20 MPs. They invited all the experts throughout India. They took all their inputs and submitted their report to the government. And again, on that standing committee report reviewed, and 2018 bill was introduced. And in again, election announced that bill was lapsed, and later, the 2019 Act was introduced in Lok Sabha, and in August 2019, it was notified in the official gazette. And but the Act was enforced in 20th July 2020. Some of the provisions, 20th, 23rd July, e-commerce rules notified, and 24th July, rest of the all sections. We can say from 24th July, whole legislation came into force. From 24th July 2020, whole legislation CPA 2019 came into force. So that is the thing. And there are, I told you, the CUS International and IIPA, very important, the statistics I will share. And one must read the state of UP versus all UP Consumer Bar Association 2016 judgments, three judges bench. And in this judgment, Supreme Court took it very serious how Indian consumer commissions are working, how members of these commissions are appointed, what is their salary, the job facilities, basic facilities, all those things are discussed. And in this case, the Chief Justice constituted a committee under the chairmanship of Justice Arjit Pashaya with two other members. They visited all the states and discussed with the state commission and members, and they submitted a report to the Supreme Court, and Supreme Court suggested a lot of changes, directed the Minister of Consumer Affairs to frame rules on appointing the members of the district commission, state commission, and central government constituted a committee also around 8 members. I was also one among them, and we framed the rules, submitted to the Supreme Court. Supreme Court circulated to all the chief secretaries of all the states to adopt, but majority of the states not adopted those things. And meanwhile, the 2019 Act enacted, and under that, the same rules are framed and circulated. Now, all the state governments have to adopt. So that is the history, how we came forward, and also how the implementation of Consumer Protection Act at the state level. You know that we have a federal system. Say central government cannot interfere in the administration of the state government, so they have a limitation. They can request, but ultimately it's a willpower of the state government to implement the act effectively. So in that angle, one research we did, implementation of Consumer Protection Act in Karnataka state. During that time, a lot of vacancies were there, infrastructure was not given. So if students did empirical research and submitted a report to, I myself went to ministry and gave a report to the officer in state government, and they have not replied positively. And then students filed a PIL against the Karnataka state government, and High Court directed the state government to appoint members, fill the vacancies, provide all the infrastructure. Then government did that exercise. So that is the history. And let us go to the statistics. Here is it's a Kurtz International Survey 2012, first point of contact for grievance reporting. So I'm talking about, see, only as on today, 2 national surveys done in India. So not no latest one. So 2012 and one is 2013 is the latest at the national level survey done. It is sponsored by Ministry of Consumer Affairs, Government of India. Hence it is authenticated. So here is a survey, first point of contact for grievance reporting. So if 100 people are aggrieved by exploitation, how many people aggrieved consumers are approaching where? So only 0.3% of the consumers are approaching consumer court, and 5% approaching seller, 2% approaching company, 0.1% approaching ombudsman. Very surprising result is 93.4% of the consumers are nowhere they are approaching to get the justice, even though they know that it is an injustice happened to them, then also they are not approaching. So these are the facts we considered, the government considered while enacting new legislation. And another thing, act was enacted, 86 Act, to help the consumers. Consumers themselves should come to consumer forum. That is the object, not to hire anybody, because it is a simple procedure, speedy in disposal, consumer friendly environment. Their members, president and members are consumer friendly. They are very cooperative to the consumers while delivering justice. So all those things, that was the object, but result is completely opposite. So 89% of the consumer cases are represented by advocates. Only maybe 1%, 9% is represented by the consumers, 1% from NGO, 1% from government body. So it shows that it should be reversed. 89 should be consumers, 9 should be advocates, but the result is opposite. That's why we have to we introspected why, what is the reason why consumers are appointing advocates, what is the need for them. So all those things we looked into, and we added changes in the new legislation. And even though as I was said, 3 months and 5 months for the disposal of the cases, delay was happening at the district commission, state commission, and national commission. So if we look into the delay reasons, so adjournment sought by advocate and parties, that self is highest. Then lack of advocate administration, support staff, education status. So these are the reasons given for the delay. So all these things are considered in the new legislation. And this is IIPA New Delhi 2013 survey. So as we have mentioned, here they have analyzed how many cases disposed of within 3 months, 5 months, so like that. At the last two, 28% of the cases disposed of within 5 months. Only 28%. 72% of the cases disposed of after 5 months. So actually law says it has to be disposed of within 5 months, but the fact is 72% of the cases are disposed of 5 months. Reasons are many. Earlier slide clearly shows that what are the reasons. So it is not only the reason of the members and president, even state government providing infrastructure, staff is also important, and state government has to appoint the members on time. If there is a vacancy, then the cases will increase, pending cases will increase. So many reasons are there. So all those things are considered in the new legislation. Let us come to the new Act, Consumer Protection Act 2019. So it has 8 chapters, and let us look into the, already if you know the 86 Act, understanding the 2019 Act is very easy. So in 2019 Act, three new chapters are added. One is Central Consumer Protection Authority. Second chapter is mediation. Third one is product liability. So only these three new chapters are added, which were not there in the 86 Act. Rest of the other chapters were there. Improved version is now in 2019. So whatever words used in central authority, mediation, product liability, those words definitions are given, new definitions are given under the section 2, under first chapter. So here the councils, about the councils, no change. The district level councils are there, state level councils and national level councils, national level council. So that is same thing is continued in 2019 with little changes. And Central Consumer Protection Authority, which was not there in the 86 Act. Why not? 86 Act was not thought of a regulatory authority in 86 itself. Whenever legislators enact a law, during that time, whatever issues are there, whatever the status is there, was there, on that basis the law was enacted. During that time in 1986, there was a legislation called MRTP Act. Under MRTP, Monopoly Restrictive Trade Practice Act, under that act, the MRTP Commission was there, which was dealing with the unfair trade practice cases. When that MRTP Act repealed and Competition Act came into force, and the Competition Commission stopped hearing the consumer and business cases, unfair trade practice. Only Competition Commission hear the business to business cases or cartel system. So then later the government thought of come out with a independent independent regulatory authority under the Act. So, and also we have looked into the FTC, Federal Trade Commission of US, many other countries' regulatory authority, and try to give more powers to this authority. And this authority is very, very powerful. And now already it has notified, and Madam Nidhi Khare is now Chief Commissioner of this CCPA, who is also the additional Secretary of Ministry of Consumer Affairs, Government of India. And now the other appointments are happening. And under this particular authority, investigating powers are there, investigating wing is there, and this authority is having a suo motu powers. Even looking into the newspaper or news item, they can convert it into the complaint. And even the consumers, if they have agreed, they can send the complaint through email with all supportive documents. And if it is affecting whole society as a class, consumers are aggrieved, then the authority will take it seriously and do investigation and take necessary action. Against the decision of this authority, if anybody is aggrieved, they can file an appeal to the commission, National Commission. So they can file an appeal to the National Commission. So that provision is given. So another thing why authority is very important. If you want to file a complaint before the commission, so first you have to satisfy consumer definition. Then to satisfy consumer definition, you have to purchase the goods or hire service. Then you have to suffer. Then you get a right to file a complaint. Otherwise, you are not getting any right to file a complaint under the Act before the commission. But here, under the authority, if you found something is unfair trade practices happening, and you have evidences, proof, then those evidence proof with a detailed letter or complaint can be filed to the authority, and authority will look into the matter. Here, there is no need for you to purchase, use, suffer. That part is removed. Directly you can file a complaint if you have a supportive documents. So ultimately, the documents should speak what you are saying. The unfair trade practice is true. So that is the change, or more powers or more helpful for the consumers to the authority, especially by establishing the authority. Coming to the commission, Consumer Dispute Redressal Commission. So this is again, all these things are discussed in detail in other technical session. I'm just giving very important points here. So this redressal commission, as it is in 86 Act, it is here. They have shifted three-tier redressal system. Only some of the changes they have made in pecuniary jurisdiction and territorial jurisdiction. So pecuniary jurisdiction, they increase the pecuniary jurisdiction, huge, up to 1 crore district commission. It is a huge. Earlier it was a 20 lakh. Now it is a 1 crore. 90% of the cases goes to district commission in future. So state governments has to establish more number of district commissions depending on number of pending cases. In Bangalore itself, already under 86 Act, we are having 5 district consumer commission because Bangalore is getting more number of consumer complaints. Similarly, in future, throughout India, more number of consumer commission, district consumer commissions may be established because pecuniary jurisdiction up to 1 crore goes to district consumer commission. That's one point. And second point is territorial jurisdiction. Earlier, why the aggrieved consumers are not filed a case? Because of the territorial jurisdiction. So CPC provision was copied and pasted under the 86 Act, that is where opposite party resides or where opposite party works for gain or where cause of action arose partly or fully, there the case can be filed. So it is more comfortable for opposite party than consumer. So that's why we requested to the drafting committee that where consumer is residing and works for gain, that can be added. At the beginning, little bit resistance was there. No, you cannot change this much drastic. When I shown some of the documents, some of the other legislation, matrimonial family course act or MEC, where a weaker party is there and the law should help the weaker party to file a case. So in they convinced and they have added that particular clause where consumer is residing and works for gain. This is another thing where the more number of cases can be filed in future under the CPA 2019 Act. So all these good things have happened. And also one of the loophole was implementing execution of the own order. So section 25 was very weak. So now full power is given to the consumer commission. It can execute its own order as if it is a civil court decree. So like that, a lot of changes have been made in the consumer commission. More powers are given. Only my concern, looking into the past experience and the statistics, whatever powers are given to district commission, state commission, national commission should be utilized so that the one who is a habitual violator or exploiting the consumer, they should learn a lesson. They should not repeat the same thing in future. So it should be deterrent by using all the powers which are given under the law. So that is about the commission. And even in the appointment, they have procedure, they have changed appointment procedure, especially selection committee. And another very important thing is that they made a rules, especially I referred UP Bar Association case, Justice Arjit Pashath report. In that, they have clearly mentioned, and I know personally, I visited all the states in India, and I found that very meager remuneration is given to the members of district commission or state commission. Very meager. They cannot offer a reasonable life in a city. So that much meager remuneration was there. And that's why that is discussed even in Supreme Court, and rules are framed now. And these remunerations of a district commission in each state, maybe under the 86 Act, some states they were giving 20,000 for per month for district commission member. In some states, Kerala around 40,000. In some other states, 15,000. So like that, which is unreasonable. Even it is lesser than minimum wages. So that was the I mean position. Now they have prescribed the designation. If member district commission is there, that deputy director's salary and all other perks. And if his person is a state commission member, he should get deputy secretary salary and all other perks. Still, the state governments have to implement that particular rules, so that everybody is benefited. And in future, the intellectual people can think of joining the commissions to deliver justice. So that is the intention behind this one. And coming to mediation, again, reason of mediation chapter is delay in disposal, that statistics. So only 28% cases disposed of within 5 months, the rest of them above 5 months. So even those cases can be referred to mediation. So if through mediation, if it is settled, it's good. Mediation is nothing but both parties willingly settling the matter through mediator. Mediator is appointed by the district commission or state commission or national commission, and both parties he will call, and he will facilitate both the parties, understand their mentality, mindset, and tries to settle the matter in the interest of themselves. And it's a win-win situation. Mediation is win-win situation. Both parties will be happy, and they go home. So that is the idea of mediation. Now, already central government requested state commissions to get infrastructure details. Maybe some funding may come from Minister of Consumer Affairs, Government of India, to establish mediation. But meanwhile, they have to start with the existed infrastructure, with the existed whatever available, because already act is enacted, it is implemented. Now district commission, state commission should use this mediation chapter in the interest of legislation, as well as in the interest of consumers. Then product liability chapter is another new chapter, very, very important chapter, because earlier also we used to cover under the defect definition, deficiency definition, but here it is explained in length under the product liability chapter, who is product seller, product manufacturer, product service provider, all those people, when they are, what are their duties, responsibilities, and when they are held liable. So all those things are discussed. Earlier, what happens, the same product is, look, the nowadays multinational companies, they are selling in US, Europe, India also. Same company is selling qualitative products in US and Europe, not that much qualitative in India. They are not strictly following in India, but there they are following strictly, because they know that here the implementation is weak, or consumers are not serious about their rights. They may not file a cases against what they are doing wrong. So that's why they continue. So now this chapter will help the consumers to exercise their rights, and also these companies, whatever they have done in past, they cannot repeat the same thing in future. So they are they should take it very serious of this chapter. Otherwise, the authority will take a very strong action against these people. Then offenses and penalties. Yes, the penalty is increased, the fine is increased. Earlier, under 86 Act, there was no imprisonment punishment. No imprisonment. Imprisonment was there under the 86 Act only to the extent of Section 27. When the order was not followed by opposite party, then that section 27 was used. But now under the 2019 Act, the authority can use the imprisonment order, issue. So even commissions. So these things are now under the new legislation. So even though earlier we call it as the Consumer Protection Act is a civil in nature, now it's a mixture, civil as well as criminal in nature. So even imprisonment power is given. So see, another very important thing is lot of powers are given. You take execution, you take imprisonment, all these things. Proportionately, infrastructure should be given to these commissions. Otherwise, this act cannot be implemented effectively. So willpower of the state government is very, very important. And the again state commission or the district commission members and even institutions of that state, they should convince the state government concerned minister to provide infrastructure to these district commission and national commission, so that the new legislation can be implemented and the consumers can be benefited of that particular state. So that is the idea behind this legislation. Now it is 11:45. So just I will run through some of the important thing within 1 or 2 minutes, and I conclude. So these are the rules and regulations enacted under the 2019. Then the all consumer definition, other things, justice has explained, rule of central authority, powers of the consumer, especially investigating powers to the authority, deficiency definition, goods definition is broadened. Earlier, goods means as per defined under goods sale of goods act. Now they changed it to movable property, any movable property, even including food as defined under food safety FSSA. Then e-commerce service provider is defined. Then e-commerce rules are framed. I said what sir was telling about a very important thing here: duties of e-commerce, liabilities of marketplace e-commerce entities, duties of seller, duties and liabilities of inventory e-commerce. So everything is discussed. That will be dealt by Pratima today. And advertisement is discussed. So endorsement, justice also discussed actor, actress. Now somebody gives a huge money, whatever they say, they tell in the advertisement, that cannot happen in future, because they are also jointly and severally held liable for misleading the public. So before doing it, they should ask the manufacturer or advertiser or service provider, what is the authenticity on which they are doing advertisement? Is there any lab test? Is there any survey? If that survey or test is recognized by any department, government department, they have to cross check and they have to put it in the agreement. Then only they can do that. Otherwise, they will be directly responsible for that act. Then unfair contract, new definition added. Territorial jurisdiction, I said the change. Pecuniary jurisdiction, I have already repeated. And up to 5 lakh, no court fee, I have discussed. Procedure for admission, electronic mode is recognized. Review powers are given to district commission and state commission. Earlier, it was not there. Appeal to the district commission to state commission, other than mediation settlement. Once a settlement happened in mediation, no appeal is allowed. And service definition, no change in the service definition. Whatever was there in the 86 Act, same thing is kept in the new legislation, CPA 2019. No services are removed. There was a little bit rumor that medical profession or health service is removed. It's completely wrong. Whatever position was in 86, same thing is continued. Even now, VP Shanta case holds good, and that will be dealt in detail by Kantikar sir. So appeal to the National Commission, all appeals are not allowed. When there is a substantive question of law is there, then only it is allowed. So administrative control, now onwards, National Commission on State Commission on District Commission, even inquiry can be done. Enforcement of the orders, as I said, full executing its own order as if civil court order, non-compliance and mediation chapter completely given, and power of state government. This is the thing where I want to stress, because it is a case went to Supreme Court. It was heard by 2-3 Justice Thakur, Chief Justice of India. Then he started, and later uh, other judges, Chief Justice took that case. Even Deepak Mishra, CJI, he took it. So the 2-3 Chief Justices handled this case, and each one delivered a very good interim order or inquiry, all those things. You should read that. And if you read that judgment, you come to know what are the problems the state government or district commission, state commissions are facing. That's why this proviso here it is made, that central, even though the powers of state government to make rules is there, majority of the state governments not more bothered. They are not framing rules at all. So, and if they make a rules, so one state, one way, which is very pathetic way they frame a rules. So there is no uniformity throughout India. Reasonable uniformity. We are not talking 100% uniformity, reasonable uniformity. So that's why this proviso added. What proviso say that central government makes a rules under this also. So these rules are applicable until state government makes a rules. And when state government makes a rules, it should see that it should be conformity with the model rules of central government, so that we can see the uniformity throughout India. So that is the object behind it. And as I said, challenges are before us. Implementation is a great challenge. State level, state government willpower is very, very important. As I said, the federal system is there. Central government cannot interfere in the state government. They can request and they can fund a little bit, but ultimately majority of the things should be done by the state government, because it is for the state people, state consumers. So that is the idea, I mean, the challenge before us. I hope all state governments will take it serious, and the institutions, the NGOs, they will take it very serious, and also the state commission and district commission together, they convince the state government to get this infrastructure. So with this, I conclude. Thank you very much for patient hearing. If any questions are there, I am happy to answer.
Thank you, sir. We have a few questions. One of the first question is whether the definition consumer includes a person who avails any service under contract of service.
See, service definition is clearly given. Under the service definition, two people, I mean, whosoever hires a free service, that person is not a consumer, and also the contract of service. So both are excluded in the consumer section 2, clause 42. Section 2, clause 42 of 2019. Last two lines, what it says, but it does not include the rendering of any service free of charge or under a contract of personal service. It is clearly mentioned. So as per that, that person is not a consumer if it falls under this definition. Yes. So,
Yes, ma'am. Any other questions? Is it over?
Yes, ma'am. Then we have another question, that is, can a lawyer and an education institute be brought to court in Consumer Protection Act?
See, about against the advocate, one case is pending before the Supreme Court. That is Gandhi case, which is pending for a longer period. It should not happen, but it is pending for a longer period. So under the Consumer Protection Act, no services are exempted. It is clear object of the legislation is to cover all the services, maybe even including government services where the consideration is there. So here, the advocate is also providing a service for consideration like doctors or other professions. So under the Act, there is no exemption, but the case is pending. Stay order is given by the Supreme Court. Still, it is pending. I hope the judgment will come at the earliest, and looking into the object of the legislation, it will say that the even advocates are covered.
Okay.
Another educational institutions, see, one landmark judgment was given the Bihar examination board case where examination related, and that board is not covered like that, they have said. But another case in which it is discussed in length, the Lucknow Development Authority case, they are divided into two. Examination related, evaluation related, examination result related, those things are not covered. Other than administrative type of thing, if institution says I'm affiliated to Bar Council of India and took a admission, and later they come to know that it is not affiliated, so those types of prima facie things can be brought under. But yes, there are contradictory judgment. But as per the Consumer Protection Act, if the person who is hiring a service from the educational institution, other than that part, not 100% it is covered. Not 100% it is covered. Yes, some extent it can be covered, and some extent it is not covered. Again, depending on what type of allegation they are making on that basis.
Okay, sir. Now we have another question, that delay in disposal of complaints. How is it taken care in the new act?
The earlier also it was there. Now also it is there. When after 3 months, if a lab test is not needed, case has to be disposed of. 5 months lab test is needed. If they are crossing, the members and president, they are crossing that period, then they have to write the reasons on the order sheet why they are giving adjournment even after 5 months. Valid reasons they have to mention. Without valid reasons, they cannot give adjournment. That's one thing. Second thing, even after let us without valid reasons, if they are adjourning, let us put a huge cost on the party who is wants to drag the case. Huge cost. If consumer is coming to the Consumer Commission and opposite party drag the case, then that consumer, whatever expenses he incurred on that day, and he took a leave, he came to this place, 1 day food outside, so together with plus some amount, let us put as a penalty, huge penalty, next time that person may not ask for the adjournment. And other than this, if both parties are ready, through mediation it can be settled. Mediation is another method where quickly the case can be settled.
Excuse me.
Yes, sir.
So I guess that's it. We have no more questions or doubts. So first of all, I would like to thank you, sir, on the behalf of Navrashna University for participating and showing us the way. Sir, it has been a great and excellent insight in the drafting of the Consumer Protection Bill, and your personal views had added, and personal views and experience just gave us a practical view of this bill. So, sir, we thank you a lot for increasing our knowledge.
Thank
Yes.
you.
Yes.
Thank you,
One
sir.
second. Yes. Tarush, 1 second. Ashok Patil, sir, thank you very much on behalf of Navrachna University, on behalf of my student, faculty, and entire team. I extend my heartfelt thanks to you. Not only for being as a panel speaker for today, even you extended a great support in organizing this event today. And one more thing, sir, your presentation, what I noticed is you not only throw a light on overall what are the changes that we come across in the consumer law, but the role that you played being a member, being a part of in recommending the government in coming out with a lot of changes in the existing act. I hope it is going to serve the purpose in future. Thank you, sir. Thanks a lot.
Thank you.
Sir, there is a question from Mr. Sankar. I would be unmuting him. He wants to ask you something.
Yeah, please.
Hello.
Yes, sir.
Very good morning.
Good morning.
Sir, this is regarding, I have two issues, two questions. As far as Tamil Nadu is concerned, all the consumer commissions are not functioning for so many months because of the vacancies. This already I have discussed with you in the last seminar also, hope you remember. At present, out of 64 members, there are only 11 members. So 53 members are vacant. As far as president is concerned, in 30 presidents, only 6 are there, 24 is vacant. Justice, Honorable President, National President quoted that delayed justice is denied justice. Like in this scenario, how the consumers will get this justice? And the 2019 Act says 21 days of admission of cases. So I wrote letters to President of Honorable Prime Minister, President of NCDRC, Supreme Court, everywhere. But we are not able to get the justice. In this scenario, how the people in Tamil Nadu will get justice, number one. Number two, as far as section 102, in Tamil Nadu, the rules is not yet framed. Is it mandatory, the rules to be framed by the state, or that can be taken as a model rule? These are all the two questions. Thank you.
Yeah, sir, as I have mentioned, we have a federal system. Central government has a very limited intervention in the state government administration. And in this angle, same thing was in Karnataka. And we filed a writ petition PIL before the Karnataka High Court. Similarly, you can also, as a NGO or through institution, you can file a PIL before the Tamil Nadu High Court to direct the state government to implement these things. Especially vacancies thing is very serious. Under the Act, rules clearly says the state government knows when these people will be retiring, because 5 years is the period. So well in advance, 6 months before that, they have to start appointment procedure so that there should not be any vacancy. That is the intention of the legislators. But even after that, their vacant positions are there. It should be taken it very serious. So if they are not convinced with a proper way, then court is the another way where you can implement these things effectively. Second thing about section 102, it is clearly mentioned in that nowhere it is said that it has to be adopted like that. So directly these rules can be adopted. There's no separate rules are needed. And if you are clearly mentioned, if you want to come out with your own rules, if it is delay, then the existed central rules are adopted. No confusion in that. And another thing, if you want to frame a rules, the compatibility or confirm. So you read the word, provided that central government may frame model rules in respect of all or any of the matters with respect to which the state government may make rules under this section. and where any such model rules may have been framed in respect of any such matter, they shall apply to the state until the rules in respect of that matter is made by the state government. So until state government make a rules, the central rules are applicable. And while making any such rules, so far as is practicable, they shall conform to such model rules. So that idea behind, if you this particular paragraph, you can in detail you can understand if you read those 2-3 judgments of UP cases. Justice Deepak Mishra, Justice Chandrachud has delivered that. So all these things connected. So, but only thing is willpower of the state government is very, very important. You have to convince, and I will try my level best at the central government level to issue circulars to the state governments. And also I try to contact, request a national commission to send a letter to the state governments. So only to that extent, I will try my level best. Thank you.
Thank you, sir. Thanks for your answer. I humbly request you to intervene in the subject because we wrote a letter to Supreme Court and they have acknowledged my mail and they have given a acknowledgement number also. It is stating that it is in process. And also we have sent a letter to NCDRC also. So kindly intervene in this matter and you please talk to the registrar of NCDRC to write a special letter stating our data to the government of Tamil Nadu to fill up the vacancies. Thank you so much.
Yes, sir. Whatever you wrote a letter to NCDRC, Supreme Court, and anywhere, you consolidate it, and with one cover note, you send it to the Secretary, Minister of Consumer Affairs, Government of India,
Yes.
and make a CC to me. Make a CC to me, then only I come to know that what you have written and what is the status. Otherwise, I'm in. I don't know.
You kindly provide your email in the chat box. I will send it to you. Already I wrote a letter to the Prime Minister grievance online and the Secretary and the Ministry of Consumer Affairs everywhere. Those who are all in India, we have addressed. We are not able to get the justice.
Yeah, consolidated all these documents in one email. Send it to me, sir.
Okay, please kindly provide your GI.
Yeah, I will do that. Thank you.
Thank you.
Thank you.
I guess that's all for the questions, sir. I would like to again thank you, sir, for sparing your time and giving us the valuable insights on this bill.
Thank you very much.
Thank you, sir. Thank you. Tarush,
Yes, ma'am.
can we have?
Now we have Advocate Rajdeep, sir. Rajdeep, sir, are you here?
Tarush, Advocate Jaideep Verma.
Sorry, Jaideep Verma, sir. I'm so sorry.
Okay.
Yes, I'm here.
Yeah, good morning, sir. Good afternoon, sir.
Good afternoon.
So if we have the permission, shall we start, sir?
Definitely.
Thank you.
Lawyers have a way of seeing things that set them apart from rest of the earth. In some way, this special vision makes them invaluable. In others' way, repulsive. Good afternoon, everyone. We welcome for technical session 2. It's an honor to have with us Advocate Jaideep Verma, sir. Sir did his graduation in BSL LLB from Symbiosis Law College, Pune. He is a certified holder of course on private international law run by the International Court of Justice, Hague, Netherlands. Sir is an ex-associate with Ms. Crayford Bailey and Company, Solicitor, Mumbai, Pan, Gujarat. Sir practices in District Court, Revenue Court, Consumer Court, Judicial and Quasi-Judicial Authority, Documentation and Title Clearance. His expertise lies in area of land and civil laws, arbitration, cyber, crime, IPR, and corporate law. Sir is an independent director of 20 Microns Limited, Baroda. Sir is ex-director public interest on Vadodara Stock Exchange appointed by SEBI, committee members of IPR and legal cell of Gujarat Chamber of Commerce and Industry. Sir was appointed arbitrator and also served as chairman of Vadodara of the board committee of Vadodara Stock Exchange. Sir is appointed as panel member of Investor Grievance Resolution Panel by National Stock Exchange of India. Sir has acted pro bono trustee in Bal Bhavan Baroda, Joint Secretary Heritage Trust, committee member Pathshala Mental, and board member Chhatra Sansad Vadodara. We welcome you, sir. Please take over the stage.
Thank you very much for the welcome. I would like to begin by thanking Dr. Sujata Patil for granting me this opportunity. I would also like to thank Dr. Ashok Patil for imparting his very, very detailed and insightful analysis of the act which he has championed. I think the contribution of Dr. Ashok Patil and his colleagues who have led to this new act being now enacted is a huge step in the legal framework of our country. Our country, as I understand it, has a very, very rich and very old, ancient system of justice administration. However, it has, over the last about 80 years, it has been gradually evolving into a framework of law, which still requires many, many changes. It requires changes which are adapted to the situation of the day. So we have to, in terms of the legal framework, we have to change with each day. And the change has to come from the provision of a framework. It's all, very easy to say that these changes, as and when the world changes, when the economy changes, when the pandemics come in, when there are new situations, people will adapt. But to adapt, the government has to provide a framework, and the government has to arm the common citizen with a kind of strength which comes in the form of a law for the common citizen to be able to very clearly exercise his legal rights. Human rights has been one of a very critical part of any country. I would consider the Consumer Protection Act also to be very similar in nature to the basic human rights that have to be provided to each citizen of India, which is why Article 21 is inherently, the Consumer Protection Act is inherently part of the right of a human being to be able to exist, exercise his legal rights, and not to be exploited or to be put in a situation where he is at a disadvantage. In our day-to-day life, we come across many, many instances where we have seen that we are forced into a situation where, when there is a grievance, we are told, but you were aware of this, and you signed on this, and you have agreed to this. See, here it is. And we go back to that and we find that, yes, we have put ourselves in a situation because the law has not supported us. As a child, I would like to share one incident with you. As a child, I just got my driving license, and I had to drop somebody off to the railway station, and I took that gentleman with me, dropped him at the railway station, and I had to go inside. So I parked the vehicle in the parking lot. I was issued a small ticket for, I think, 2 rupees at that point of time. And I paid that 2 rupees. I parked the car. When I came back 20 minutes later, I found that the car had been hit by some other vehicle. Now that other vehicle was no longer there, obviously. So I asked the contractor, the person who had issued me the ticket, I said that this is what has happened. So he says, "Nahin, we have you see the backside of the ticket, it says that we have no responsibility for that. You have parked your vehicle at your own responsibility." Now, in day-to-day life, even today, there are so many situations, thousands of situations where we are doing the same thing. At that point of time, I went off, licking my wounds. I said that now how do I, deal with this gentleman? Because yes, the ticket said that it is your responsibility. So it was something that I had been forced into. Now, in today's world, we are facing this situation as consumers. Very often, as a consumer, you and I, we purchase things, we avail of services, and we expect a minimum level of what return on what you have paid for. But there are larger players in this. I'm purchasing, say, for example, some goods from a very large chain of shops. So their reach, their ability to work into a contract, whatever it is that they want to say, all that has been taken care of well in advance. So as a consumer, I am too small to really be able to fight them legally. However, the gradual amendments and the precedents set by the honorable courts, starting from the district forums all the way up to the honorable Supreme Court, they have ensured that the common citizen is empowered and is daily being empowered to ensure that he is able to fight for his own rights. The 2019 amendments that we are today currently discussing has in fact done some fantastic changes in my personal opinion. The changes have ensured that whatever the lacuna that was there in the previous act was also very well thought of. However, it was been evolving, and we are a country which has its own set of challenges in terms of the fact that facility is not available in the same way in the same city or in the same way in the same state. So there are these dichotomies that we face, which are actual practical issues and which will ultimately evolve over a period of time. However, once there is an act like this, or once there is a system set in place, this can only evolve into something better. So I am really looking forward in the next couple of years to seeing that the effect of this act percolates down to the common man. This will be probably at a personal cost, and I'm saying this in a lighter way, that as Dr. Patil just said, that ultimately there has to be, the larger pie has to be of the consumer who goes to court and not of the lawyers who are fighting the cases. The lawyers have actually no say in this. The lawyers were originally, if you go back into time, why was a pleader, as he was called, hired for his services? He was hired for his services when there were complicated issues of technicality which an ordinary man would not understand. The Consumer Protection Act should empower the common citizen in such a way that the lawyers are not required. However, the judges are required, experienced judges, experienced technical members like medical professionals, or common citizens who have a good stature in society and who would be impartial, would be using their common sense, and hence the system would become very robust. Today, what is happening is that the lawyer, using his acumen, very often gets the better of a grieved common man who has had an issue as a consumer. So on a technical ground, there are so many cases that we as lawyers are able to steer in a certain way, which ultimately, though it is said to have done justice, but the justice does not percolate down to the common consumer. The same way, I think, the way the redressal mechanism has been fortified in the enactment, in the new amendment, is also very, very good. One or two very, very salient features that I am really looking forward to in the next, maybe say 15 years or so, which will turn to be very effective. One is the Central Consumer Protection Authority. The second is the mediation. Now, mediation worldwide has been held to be a very, very efficacious remedy. Because of mediation, many, many cases will be resolved in such a way that both the consumer and the opposite party will come to a conclusion as to how to end their dispute. And that conclusion will be a win-win situation for both the parties. So that is another very, very important thing that has happened. To begin, I would like to dwell a little on the Central Consumer Protection Authority. The advantage of this authority has been that it is an authority that will on its own be able to file complaints before the various forums. The three forums that we are aware of today, which a consumer can approach, are the district forum, the district being the district that the consumer hails from, the state forum, which is at a level of his state. So for example, if we are in Gujarat, then it would be Ahmedabad, because that is the, though it is not the capital, but it is the commercial headquarters of, and the seat where the High Court is. So it would be Ahmedabad. And then there is the National Consumer Forum. So Commission, where ultimately the law, as far as the consumer complaint is decided. Previously, it was also decided keeping in mind the facts. Now that is now being narrowed down in view of the fact that there are just too many complaints which are going up all the way to the NCDRC. So this, the CCPA has been now granted sanction. It is a legal body which will have perpetual succession, and it will have the power to acquire, hold, and dispose of property, both movable and immovable. It will function in such a way it will regulate the violation of the rights of the consumers. It will regulate matters relating to unfair trade practices and false and misleading advertisements. All these three are prejudicial to the interests of the public and the consumers. And it will help in enforcing the rights of the consumer as a class. This is another very, very important issue that has come up, which is now the consumer will be able to fight as a class, as a group, and not as an individual if necessary. The actions and the acts of the CCPA will be, appeals from that will be preferred to the National Commission. The CCPA can inquire or cause an inquiry or investigation to be made into violations of consumer rights or unfair trade practices. It can also, now this is very important, it can also intervene in proceedings before the district commission or state commission or national commission in respect of allegations of violation of consumer rights or unfair trade practices. Now, this is a huge step. This is like an independent body taking upon itself the role of supporting a consumer in his fight for justice. So the CCPA, where suppose there is a consumer who has very less wherewithal to file and fight and agitate his consumer complaint, but the consumer, the CCPA finds that this is an issue, this is a cause that needs to be supported because it has larger ramifications, then the CCPA can intervene, and it can intervene in proceedings before the commissions. The CCPA can review the matters that are relating to and factors inhibiting enjoyment of consumer rights, including safeguards provided for the protection of consumers. It can recommend appropriate remedial measures for their effective implementation. It can recommend adoption of international covenants and best international practices on consumer rights to ensure effective enforcement of consumer rights. Now, this again is, we will see this in the next maybe decade or so, how the CCPA and the activities pan out, because our country in terms of basic rights is different from say what are called the developed countries in terms of their basic rights. The premium that is placed on the basic rights of a citizen in, say, for example, the United States of America is different from the importance that we give ourselves in a situation where we are aggrieved in a place like India. There is this very celebrated, and I'm just giving this one random example, that there is this one celebrated example of a huge amount of claim being granted to a person who slipped on the floor, on the shop floor of a mall, because the floor was wet. Now, this, as I see it, would be a very small thing in India. People would not even think twice about it and would say that, oh, it was my mistake. However, in a developed country, it is taken so seriously because the shop had certain legal rights and liabilities especially, that it should have ensured that the floor was not available to walk on when it was wet. Now, these and many more things like this will be adopted by way of the CCPA recommending the adoption of international covenants. International covenants from all over the world will be taken into consideration and hopefully will be implemented in enhancing and in strengthening our consumer protection redressal forums and system. The CCPA will spread and promote awareness on consumer rights. So it will act as a body in which it will take up upon itself the action of spreading and promoting awareness on consumer rights. This is again very important. The common man very often doesn't even know that he has these rights, leave alone having the ability to protect them, leave alone the ability to go to court, file a complaint in triplicate, pay court fees, understand what stamp to affix, understand that it might require an application to hire a lawyer, not to hire a lawyer. So all these technicalities will be explained to the common citizen by the spreading and promoting the awareness. The CCPA will encourage non-governmental organizations and other institutions working in the field of consumer rights. That again is very important because there are many very well-meaning NGOs and awareness groups who are helping the common man. Now, the CCPA will encourage these and will probably will help them come together under a particular umbrella so that the common man ultimately is held. We recently heard this, just 10 minutes back, we heard this gentleman from Tamil Nadu who had a question and he had a grievance. Now, it probably is also within the domain of the CCPA to interfere in an issue like this and resolve this genuine grievance that there are not enough members available to man the courts, or they have retired, or whatever the genuine difficulty is. The common man is ultimately affected, however genuine the difficulty may be. So this may be something that the CCPA can look at. The CCPA can issue safety notices to alert consumers against dangerous, hazardous, or unsafe goods or services. It can advise the ministries and departments of the central and state governments on consumer welfare issues. And it can issue necessary guidelines to prevent unfair trade practices. One issue that has been of interest both to the media and to the common man, because today we are in a time when social media is very powerful. We are all on some form of social media, and we are all, in fact, we are currently on a platform which was unknown maybe a year back. So we are all now very much more in the virtual world. Now, while we are in the virtual world, we are very often being faced, and this is from the point of view of the Consumer Protection Act, that we are very often faced with companies and organizations trying to sell to the common man their various products in terms of goods or services. These are all provided via the internet, via multi-marketing, via social media, where these become what is called a misleading advertisement. So it falsely describes a product or a service. It could also give a false guarantee, or is likely to mislead the consumer as to the nature, substance, quantity, or quality of such product or service. Or it conveys an express or implied representation, which, if made by the manufacturer or seller, would constitute an unfair trade practice. Or it deliberately conceals important information. In the times to come, today we are in an age where there is so much of advertisement going on, that in the times to come, this will become very important. It will also throw up some very frivolous cases that will also be, from the technical point of view, it can almost be correct. However, ultimately it will be held that it was not. I'll give you a small example. I have read about a deodorant which is being branded, a branded deodorant which was being made available, saying that if you use this, you will attract the attention of the opposite sex. So a gentleman using this will make lots of female friends if he uses this deodorant. Now, one such gentleman purchased this, used it, and he claims to have used many of them, and then went to court saying that this didn't work and I didn't make any new friends. So this is an issue that will also crop up. But the bottom line on this is that this advertisement itself is suspect. Could an advertisement like this have been really permitted? If so, would it not cause a common man to believe certain things that he should not have believed? So in a case like this or similar cases, the CCPA can investigate whether the advertisement is fake, misleading, or prejudicial to the interest of the consumer, or is in contravention of consumer rights. And it may, by order, issue directions to the concerned manufacturer or endorser or advertiser or publisher to discontinue such advertisement, or it can ask him to modify. The CCPA has the discretion to impose penalties. It can prohibit the endorser of a false or misleading advertisement from making endorsement. So it can stop a person from making such endorsements. It can prohibit, and it can also impose a penalty on such advertisements. This has again been a very, very interesting issue that has been going on, that we have, in our country, we have many role models. So, without getting into the right or wrong of it, we have many cricketers who are role models. We have many Bollywood actors who are role models. Sometimes we have, a boxer who's a role model. Now, once these people become very, very, important, and they are in the limelight, and they're recognizable, and they have a lot of face value, the common man starts to think that whatever they say is actually true. So very often, service providers and goods providers use these people in their advertisements to push certain products of theirs. Very often, these products or services are of value. Very often, they are not. Now, in a case where they are not, or in a case where they are misused, what happens to the person who provided his screen presence? There is a recent controversy going on in Baroda, where a certain well-known retired cricketer had endorsed a particular resort chain, saying that if you buy timeshare in this resort, you will be eligible for so and so facility, you will get this, you will get that. And many promises were made. Then the promoter of that particular resort and timeshare could not fulfill his promises. And many consumers got caught in that after having invested good money in that. Some of them went to the district consumer forum in Baroda and sued both the promoter and the person who endorsed. And there was an interesting judgment which fined obviously the promoter, and they were made to return the money with interest and all that. But also it was held that the person who lent his name, fame and glory and photographs for endorsing these services was also penalized in terms of money. So very soon we will see that people who are lending their names just because they want to earn money out of it, because of the fact that they are famous. And so sometimes it is not a very responsible act of a person to lend his credibility for pushing or promoting such products or services which may be effective or non-effective. If they are effective, then it's not an issue. But if they are non, or if there is a situation where there is going to be a default, then the common man is going to get stuck because he believed that this particular actor or cricketer or whoever he was should have been followed. So the CCPA can take action like that. Another very common, another very new and novel issue that now will be taken up by the CCPA and by the consumer courts in India is the class action. Class action suits, where I think the genesis was in the United States and the developed countries, where a group of people having the same interest would have one proceeding or multiple proceedings with the same cause of action, and the court would consider them as a class. And instead of each person then joining in his own personal petition, a common order would be achieved whereby the justice would be meted out to the entire situation. So there is a recent judgment of the Consumer Protection Courts, the NCDRC in fact, whereby the appellants had booked office spaces in a project, and that office space was not delivered on time, but and was not delivered in the way it should have been. In that, the National Consumer Redressal Commission held that the scope of the complaint was not restricted only to the complainants, but it would encompass all the allottees of the project. So each and every allottee of the project who had been aggrieved by this, the order of the NCDRC would have been relevant to that and would be applied. Another case, one Mr. Ambarish Kumar Shukla, the National Commission observed in that the purpose of giving a statutory recognition to such a complaint being to avoid the multiplicity of litigation. The effort should be given to an interpretation which should subserve the said objective by reducing the increased inflow of the consumer complaints to the consumer forums. Reduction in the number of consumer complaints will be cost effective, not only for the consumers, but for the service provider. Hence, the interest of the persons on whose behalf the claim is brought must be common, or they must have a common grievance which they seek to be redressed. This is a very, very big and positive step taken forward. We today in all the courts, may it be the District Forum, State Commission or the NCDRC, we are unfortunately swamped by the number of cases that are being filed. They are all cases with genuine, difficulties. However, the mechanism of the courts and the number of cases are not able to match up in terms of delivery. There are many issues to that which I'm sure are being looked at, but there are just too many cases, and a class action matter would definitely help in closing out such a issue. Now, if I may dwell briefly on mediation. So class action is something that is very important. The other one was mediation, as I said. That in many laws now, like for example, in civil law, we have this 2016 enactment, the Commercial Courts Act, which is a very, very important landmark act whereby all matters which are of a certain commercial nature, and there is a detailed definition provided, would go to a designated court called the Commercial Court. The Commercial Court has very strict and stringent timelines, and it has very strict and stringent procedure. So that commercial disputes, what usually originally was called luxury litigation, however, they were all disputes out of contracts, and hence very relevant from the point of view of investors from abroad, of the point of view of companies who are doing business in India. And it gave a great impetus to the faith of the people who had signed the contract to the efficacy of the contract. So in that Commercial Courts Act also, there is what is called compulsory pre-institutional mediation. This ensures that disputes which can be sorted out before the court mechanism is put into place and used, there would be a mediator appointed by the court, a trained mediator who would understand how getting two people together and sorting out their differences is important. They would be trained in ensuring that the two people reached a certain consensus. So now under the the new act here, mediation is again is being it's being made compulsory, which would be a huge step, because many disputes which have reached court because the two parties never saw each other, or were never able to communicate, or were never given the chance by their advisors, will now be able to sit across and say what the grievance was, and the other person will say what the remedy is. So many disputes will get sorted out in mediation. The mediation will be in such a way that any matter by consent will be referred to mediation, and the mediation can solve these disputes. Each district, state, and the National Commission will have a mediation cell. Now, I am sure that this will soon happen, and it will be effective and efficacious. The procedure will be that if an agreement is reached between the parties with respect to all or some of the issues, the terms of such agreement will be reduced to writing and signed by the parties. Where the consumer dispute is settled only in part, the state, district, or national commission, as the case may be, will have to record the settlement of the issues and continue to hear the remaining issues. So hence there will be only a little part of the dispute that can be then decided by the court, hence saving so much of time and money of everybody. However, if an agreement is reached with regard to all issues, the mediator has to provide a settlement report and forward the signed agreement to the commission or the district forum in a sealed cover with a forwarding letter. And the district, state, or national commission, within 7 days of the receipt of the settlement report, will pass a suitable order recording such settlement, and the matter will stand disposed of. However, in the eventuality that no agreement is reached and there is no settlement possible, then the matter will be relegated back to the court. I think this is a huge step, because mediation, in my understanding, I have seen many such cases where, because of a good person involved between two people who have had a dispute, or two entities which have had a dispute, have been able to resolve the differences because of the third person. The egos are down, there are no legal defenses, there is no lawyer around, and they sit across and they sort out the difference. The process is that it has to be completed within 3 months, unless the time is extended by the commission. Parties have the right to be heard. So that's a very important thing. They have a right to be heard. Principles of natural justice should be followed. Though procedurally, the Civil Procedure Code or the Evidence Act is not applicable. The parties can appear before the mediator in person or through the respective representatives, which in fact I would dare suggest that it should be actually in person only. Only then can the real thing be culled out and decided. And the parties are to provide all such information as may be required by the mediator. A record of the proceedings has to be prepared by the mediator on every date and signed by each party. And the mediator has to act as a facilitator for voluntary resolution of the dispute, and the mediator cannot himself impose any terms of settlement. And the most important, confidentiality will be maintained in the mediation process. That is very important. So these are things that I personally, as a practitioner in a district, I am really looking forward to in seeing in actual implementation. And let me share with you that ultimately any matter, however keenly contested in the Supreme Court ultimately where it attains finality. However, it has emanated from the district. The core of the dispute is in the district. The grievance is in the district. The pain is felt in the district. And hence, this is the place. The district is the place where all issues ultimately are either taken ahead or dropped or modified. The foundation is laid in the district. And hence, such enactments or such amendments, if they are implemented well in the district forums, it will really help in changing the entire face of this particular law. Now, the standard redressal forums that we all are aware of are the district forum, the state commission, and the national commission. The changes in the act that have come forth are also landmark. And landmark not in the sense that the threshold has been increased or the territorial jurisdiction has been changed or the court fee has been made in such a way that the first 5 lakhs there is no court fee. The fact is that this has been implemented and it has, on a practical level, it has been thought of. So this act looks like an act where actual people have thought about the working of the act. Very often one sees enactments where one doesn't understand. So for example, a substantive law. One only sees it as precedents because one has read precedents. In this act, I can feel that a common man's perspective has been taken into consideration. If I am traveling from, say, a place like Baroda to Bombay, and I purchase some goods in Bombay, the next day when I come back home to Baroda and I realize that the goods were defective, what do? Do I have the ability to go back to Bombay to sue or to file a complaint or to redress my grievance? Is it financially possible? No. Is it practically possible? No. Is it in any way feasible? No, it's not. Now, this law has ensured that it is for the benefit of the consumer who has been grieved, and hence it is his home where the jurisdiction would lie. So now the territorial jurisdiction of the forum is very clearly of where the complainant resides. I find that very, 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 very landmark. The 2019 Act, in terms of value of the goods and services, has changed the compensation, if any, claimed from 20 lakhs to 1 crore. So, the value of money has gone down. The value of the rupee has fallen. Today, in 1986, what 1 lakh would have fetched me, in 2020, it will not fetch me the same amount of whatever it is that I purchase. So 1 crore is the jurisdiction for the district forum. 1 crore to 10 crores is where the state forum would have jurisdiction. And 10 crores and above is where the National Commission would have jurisdiction. Now, this is realistic. And hence, it has been brought in. Issue of territorial jurisdiction we just discussed. Originally and under the Civil Procedure Code, under Section 20, it is either where cause of action arises, or part of cause of action arises, or where the defendant stays or resides or has his vocation. So that has been changed to come back to ordinarily resides. the complainant resides or personally works for gain. That D, the addition of D in the section is what is landmark. The appeals against the order of the district commission are to be filed with the state commission within 45 days of the date of the order. The state commission has the discretion to entertain an appeal after the expiry, provided there is a sufficient and genuine cause for delay. If there is a direction for deposit of the amount, the appellant must deposit 50%. And no appeal, again, this is very important, no appeal can be made pursuant to a settlement by mediation. So the time period for the appeal has been relaxed from 30 days to 45 days. And there is discretion to provide for condonation of delay. From an appeal, from an order of the state commission to the national commission, the period remains the same at 30 days. There is condonation of delay possible if there is a genuine and sufficient cause. 50% must be deposited in order to appeal. And even if the amount is not the critical thing, if there is a substantial question of law, then the National Commission can take it up. And it can be made against an ex parte order by the State Commission. Now, this substantial question of law for the National Commission to go into might be met with a lot of misuse, because everything at some point of time becomes a question of law. So, to cull out what is substantial and what is not is going to be very challenging for the Honorable National Commission. Any appeal from the orders of the National Commission will go to the Supreme Court within 30 days. There is provision for condonation of delay, and 50% of the amount has to be paid. The Act, I'm sure all the participants here have access to, and they will read and they will interpret in their own way. I thought I would just share with you my perspective as a practicing lawyer on what I feel, as a daily issue that is being faced in the courts. And that, according to me, is what the new act has introduced. The mediation, class action, CCPA, these are three things which are landmark, and they will go a long way in protecting and enhancing the rights of the consumers. There are small issues that I would like to bring forth, which is that the entire ombudsman, there was the ability to approach the ombudsman. Somehow that has not been effective. Maybe there is something that can be done there. E-filing is something that is the call for the day today. Everything, even in the civil court, is now currently being filed by way of e-filing. And e-summons. The biggest battle that a consumer faces is getting summons served to the opposite parties. So, for example, if I've purchased a phone, say of a Chinese company, now to serve the summons on the Chinese company wherever they are based, they may have an importer in Delhi or Calcutta or some place far away. For a common man from a small village who has bought the 7,000 rupee phone, for him to get the summons issued, either through the district forum where the summons are issued by way of post, they never reach. If they reach, they don't come back. If they do come back, there is no endorsement. So there are these huge practical difficulties which we face on a daily basis. E-summons is something which is now today so good for the consumer that the consumer will be able to ensure that his summons are received, and then on the merits of the matter, whatever happens, happens. But his biggest threshold hurdle has been the service of the summons. The other thing is the fact that now virtual hearings can be held. This helps very often issues of, say, medical or repudiation of medical policies are fought by individual aggrieved consumers. So there is this 75-year-old gentleman who has had an eye operation. He has been denied his insurance on the ground that he wasn't admitted in the hospital for more than a couple of hours. These are typical cases that one comes across, and the insurance company repudiates the claim and says that no, you are not covered. Now this gentleman, for him to go all the way, get a complaint typed, then go all the way to the forum, file it in triplicate, all that is very cumbersome. However, and then appear for the hearing. In the hearing, he has to go and appear physically. He has to wait there. He has to stand in line. There are 50 other matters before him and after him. So in a virtual hearing, he is able to get his justice at his doorstep. And what more does an individual citizen of India want? He wants effective, efficacious, and delivered at his convenience kind of justice, which is also fair, true, and right in law. So I don't want to get into more technicalities of the very, very many changes that have come by in the new act, but I'm greatly, happy and very, very happy to see that there are these changes, and I hope these changes are only get better. And I thank you again for this opportunity to be able to express my views. Thank you very much.
Thank you, sir. Now we have some few questions from the participants, sir.
Please.
Sir, the first question is there any requirement in CCPA to have female members mandatory as it is there presently in all three forums?
I frankly am not aware.
Okay,
But
sir.
I think Dr. Ashok Patil probably might be able to answer that. But I'm not aware of this.
Okay, sir. And sir, another question is there any change in the new act with regard to reappointment of the same member as the member of three forums?
The same person will not be reappointed. So there would be a change.
Okay, sir. So I hope, I guess everyone's doubts are clear. That's why there are no more questions, sir. So I would like Nitya to take over, please.
Okay, Dharush. We would like to thank you, sir, for your enriching presentation, considering all practical aspects. So your case laws mentioned along with your personal encounter make this a very interesting one. Thank you so much, sir, for your precious time.
Thank you very much. Sorry, I had to turn the video off because I had some problem with my data.
That's not an issue, sir.
Yes, Jaideep Verma, sir, this is Patil. Yes, it was very informative what you shared with the audience, and really we can make out your practical exposure and being a practicing advocate. You just put forth a couple of cases, I think, which in turn it helps a participant to understand better with whatever the act or whatever the changes that we come across. Really live examples and the cases that you have been thrown to the participant. It was very quite interesting. Thank you for joining and accepting our request. Okay.
Thank you. I would just like to say that I spoke from personal experience, and I didn't speak on the technical aspects of the law. The law is very good and it is technically very sound. So I will leave that, for interpretation for everybody else also. I just spoke from my heart, from what I felt I have seen in these 25 years of practice.
Absolutely, sir. No. That is most required, because that practical exposure, what you are going to experience in your day-to-day practice, that is also very, very relevant, so that it is better to understand the technicalities involved in the procedural aspect. Okay.
Yes,
and it was quite interesting,
So I would like to share that I did a diploma in consumer protection law under Dr. S.P. Sathe,
Oh,
who I think all of you would, as academicians, will know. What a great gentleman he was. And
yes,
he
yes, yes.
said exactly this. He says, "What is this act? This
Yeah.
act is not for us lawyers. It is for the common man, and the common man should be able to implement it."
Right.
So that is what the law is all about. The rest of the laws are all very technical. You go in black courts and you give legal jargon, and the judges are within the constraints of the law. I will say constraints of the law.
Absolutely.
But the Consumer Protection Act is something that is actually, you see the pain of the person.
Absolutely.
Sir, can I ask a question?
Yes, there is question, I hope so, sir.
Yes. So my name is Rajendra Singh. I'm speaking from Bombay. It was a very, very good session with you. And as you rightly mentioned, that 90% issues can be and are actually addressed to the district forum. So my question to you, sir, is, and after hearing you and after hearing Dr. Ashok Patil, that what kind of judges or members or the panel is available at district forum? Are they really equipped to handle things, because the kind of remuneration, salary, etc. they get? And there is also political appointment. They are appointed by the state government on the basis of other factors and the competency, etc. So what kind of redressal a normal, a common consumer gets in the district forum, and how far the quality of members is responsible for the justice meted out at the district forum, sir?
Good question, Mr. Rajendra Singh. I really want to answer this. So, and I'm only talking from my limited experience of the district forum on a daily basis. Okay, the judges who are available and who I have seen over the last many years are retired district judges who have huge experience in dealing with people. They have huge experience in dealing with the law and of various laws. The district judge, Mr. Rajendra Singh, is a person who has over approximately 35 to 42 years of standing as a judge. He joined as a civil judge junior division and retired as a district judge in those 35 years or so. So he has dealt with cases from murder to land to cybercrime to dowry to everything that one can even think of. Now that gentleman heads a forum where the consumer goes to him. So this retired district judge has all the empathy and the technical knowledge to deal with these cases. So in my understanding, it's the right thing to do to have this kind of appointment. They're hugely experienced people. They've had experience in all formats of law. They've met and dealt with all kinds of people. They also know the loopholes that are available in the law. They also know the loopholes that the lawyers think of. So that, I think, is working very well. Along with them are the technical members who are appointed on the merits of the fact that they are responsible citizens of that particular area. These technical members are assisting the main judge, the district judicial member, in imparting whatever law that in exercising his ability. So they are also helping in a very good way. And my only issue here is that the appointments have to be constant. There should not be a gap between two appointments, because they also retire, they fall ill, they resign sometimes because they have relocated or health problems. So that should be a continuous process. And the fact is that there are just too many cases, so there should be more appointments. So in a place like Baroda, we have 2 courts, we should have maybe 5. This is just to give you an example. Otherwise, it is a very, very effective remedy. And see, I heard 2 speakers before me say that the consumer must exercise his right. Till you exercise your right, there is no question of anything else. You must exercise your right. And that's the way to begin with. Thank you.
Thank you so much, sir. With that, I humbly request everyone to join at 2 p.m. for our rest of the technical session. Thank you so much, everyone, for your presence.
Thank you. Thank you, Jaideep Verma, sir. Thanks a
Thank you.
lot.
Thank you.
Tarush?
Sir, yes, I'm the host right now.
Okay, okay, sorry.
Yeah.
So I just took over as a host right now.
Okay.
So maybe if you want to, all of you want to leave, they can leave. And then at 2 o'clock you join, I'll hand it over to you.
Sure, sir. Okay.
Yeah.
Thank you, sir.
Welcome.
Dinesh,
Yes, sir.
Yeah, Madhura ma'am. Hello.
Yeah, Tarush, are we ready?
yes, ma'am. Sir, can you make me the host?
Okay. Tarush is now host. Just a minute, Tarush. Let me start. Or will you start the recording on cloud?
Okay, sir, I will
Yes.
start the recording on the cloud.
Yeah. So you are the host now.
Okay,
And you can
so
start the recording when you are ready. Huh? Rest YouTube and everything is on. So just let it be on as it is.
okay, sir. Madhura ma'am, shall we begin?
Yes, the speaker is joined.
Let me just.
Yeah.
Yes, ma'am. Dr. S.M. Kantika sir is there.
Yeah,
Uh,
just you can pin sir.
yeah.
And check if it is audible to him.
Okay, ma'am.
And
I'm just messaging him.
yeah, yeah, sure.
Good afternoon, sir.
Hello, good afternoon, everyone. Good afternoon.
Sir, am I audible?
Yes, you are audible. Yes.
Sir, with the due permission, can we start?
Just wait for 1 minute. I am searching my PPT.
Okay, not an issue, sir.
Just 2 minutes, huh?
Not an issue, sir.
Huh. Yes, it's ready now. Hello.
Okay. Yeah.
Yes.
Okay, sir.
Ready. So I have to share screen, no? I have to do share.
Yes, sir. After the introduction,
Okay.
if it yeah.
Okay.
Negligence is the rust of the soul that corrodes through all her best resolves. Good afternoon to everyone present here, to Honorable Dr. S.M. Kantika, sir, and all the dignitaries and the participants present in the third round of the technical session. Mr. Kantika, sir, has done his MBBS and MD Pathology from DM Government Medical College and Law from National Law School of India University, Bangalore. He has started many blood banks in the state of Shimoga and also served as a medical director of the blood banks. He has served as a member of Shimoga District Consumer Forum for 4 years and honorable professor law and medicine at the National Law School, Shimoga. His main research subjects were impact of the Consumer Protection Act 1986 and medical negligence. He is a resource person for medical negligence and consumer law at National Judicial Academy, Indian Institute of Public Administration, IIT and IIMA, and during several national conventions in the country. From March 2013, he has joined as a member of National Consumer Disputes Redressal Commission, New Delhi. So it's an honor to have you with us. The stage is all yours, sir.
Good afternoon, everyone. I think you have finished your lunch or you have to go for lunch?
Sir, we are already done with the lunch break.
Oh, then you are fresh also and in the mood of sleep also. Huh?
No, sir. We are keen to hear you.
Okay, so thank you for the invite and thank you for your introduction also. I'm from Karnataka and joined here in 2013. The subject assigned me, where is the, shall I share now? Share screen, huh?
Yes, sir, you can share the screen.
Just host disabled screen sharing, it is coming.
Just a minute, sir. I would be giving you the screen sharing rights. Dinesh sir,
medical negligence. I will be talking just to start. Medical negligence, there are many cases, and after VP Shanta's case, the health services are included in the Consumer Protection Act. Before that, the medical negligence was dealt in the civil court and criminal court and professional regulatory bodies also. Why it has included in the consumer protection? Because of speedy remedy, you all know. Madam, shall I share the screen now? Hello?
sir, I'm just giving you the screen sharing rights in a minute, sir.
Okay, okay. Just then I will be talking on some introductory part. Okay. So I think what is medical negligence in general? I'm just giving some
Sir,
outline of this.
yeah.
Yes.
Sir, you can share now, please.
Share.
Yeah. Yeah, sir, it's visible.
Visible.
Yeah, you may put in a presentation mode. Yeah, it's visible perfectly, sir.
Yes. So we will be discussing today liability of medical negligence under the Consumer Protection Act 2019. So what is negligence? I presume the delegates most are the law students, few lawyers, few doctors, and our different members from different consumer fora in the country. So what is negligence? You all know Winfield's definition. It is a breach of legal duty to take just to take care which result in damage undesired by the defendant to the plaintiff. In this context, who is the plaintiff, who is the defendant? Doctor is the defendant, plaintiff is the patient. So patient is known as a consumer under Consumer Protection Act. I will not go into the how he is a consumer and other things. Already VP Shanta's case, Honorable Supreme Court decided that doctor's consumer is patient. So there is a consumer doctor-patient relationship also known as the consumer and service provider relationship. So if there is any breach in legal duty, we'll see what is the legal duty of the doctor now. What is the duty? Duty is the court will decide whether there was a duty of failure, there is a deficiency, or there is a dereliction. Everything court will decide. It is impossible to give one general comprehensive definition of negligence as it arises from number of relationships. So it is recognized as independent tort by the House of Lords. You know these cases, Dano versus Stevenson, and I will not go into the historical aspect. There is the need to analyze duty, care, causation, and remoteness of the damages in the given case. Court will decide this. Whether court will analyze whether there was that duty or doctor was there, whether that duty was carefully performed, and what was the causation, cause of action, and the damages. Court will decide, and the punishment of not punishment. Punishment is not in the consumer protection. Penalty which to be imposed, it will court will decide. Now you see this rising trend of medical negligence cases. The VP Shanta's case in 1995, and thereafter slowly the consumer cases were piling up in the different consumer fora in the country. So I have taken up study for my PhD topic also this and collected data from National Commission. Since 2010, To 2016 data was taken and 17 also, but it is not included. There is, you can see very rising trend of medical negligence cases being filed, which we got in the National Commission. Why it is? Whether the patient, the consumer is aware, or what is the, whether doctors are really negligent, we have to see. So now we'll come to the elements of medical negligence. Now we just saw what is negligence. Now what is medical negligence? This is a new terminology, medical law. It is a new concept of law. It developed for the last in the US and UK. It is from since very 3 to 4 decades back, and now it is evolving. And most of the medical negligence cases are throughout the world. They are filing. So elements of medical negligence. Remember the 4 Ds. It is, I have made it some different way. The elements of the one is duty. Just previous slide we saw duty, causation, and some other. So there is a 4D means duty, dereliction, direct cause, and damage. Now duty is, doctor has several duties. He has to attend the patient depending on his specialty. If he is a family physician, if he is a gynecologist, if he is an anesthesiologist, so different specialties, different duties. But as a medical professional, there is one duty. He has to attend the patient. Now the question is whether patient is different. Suppose I am a family physician, just a simple graduate, either MBBS or BAMS or whatever it is. Then what is my duty? I should attend the patient. If it is within my reach, I will treat the patient. Suppose I will give another example. A physician is there. Physician means he is a medicine. He will not involve in any surgical procedure or anything. And if he receive, or one patient will come, doctor, I had a fracture. He is going on the road and fracture occurred. Please treat me. Now it is not his duty, but his duty is to refer the patient to proper doctor. He cannot refer the fracture leg patient to neurosurgeon. So now the duty is to refer the patient to proper doctor is his duty. Treating the patient is not his duty. Now suppose if he refuses, no, I will not check you. Then yes, it is not his duty. So there is no duty, but it is not an obligation also. He has to refer to the orthopedician also. But as an ethical point of view, he has his duty, ethical duty. He has to refer to the proper doctor or tell the patient attendant go to orthopedician. So this is known as duty. Now the dereliction of duty. Suppose the patient approaches the orthopedic surgeon and there is a fracture of a leg or hand, road accident is there. The prime duty is whether the injury is compound fracture or simple fracture, closed fracture. He has to ascertain, take the patient, examine him. If the patient is telling I had road accident or fall on the stone, there is a fracture, pain in my lower limb. So if this is the complaint, the prime duty of orthopedic surgeon to ascertain whether there is any injury, fracture, or why he is complaining of pain. Suppose if he says, oh, nothing happened, you go. Take those tablets and you go. So duty of orthopedician casted, examine the patient, take the X-ray and come to the diagnosis and then further treatment. So his duty, there was duty, but he neglected. He just ignored, nothing happened, no fracture. He will examine superficially and go. He will not take any X-ray or anything. The fracture was missing also. So this is known as dereliction of duty. That is a breach of duty of care. In other words, breach of duty of care. Then third is direct cause. Now direct cause is, I will restrict to this example only. The patient went to the orthopedic surgeon His duty was examine. He examined also, and due to his some negligence, means I will give. Suppose he has not taken the X-ray at the first instance. At the first instance, he has not taken the X-ray. Only he treated conservatively because clinically he feel X-ray should be taken, or will take X-ray. He has taken the X-ray and putting the plaster or alignment, he delayed because most of the fracture patients, there should be first treat conservatively, then put the plaster, and they immediately they can't put the plaster also. So by not putting the immediate plaster, that's why I suffered this further mal alignment. We say mal alignment, or I developed because when I approached the hospital, doctor has examined me and just kept 2-3 days as it is. He has not put the plaster. Otherwise, my limb became straight. Because of his delay in putting the plaster, my deformity resulted. So this is not the thing. The fracture, the doctor's action should be directly related to it should be a proximate cause of that injury that should be there. And the damage may be physical, damage may be pecuniary. I have sustained, I have to approach few hospitals. I have suffered a number of charges and financial loss I suffered. This is the damage. Damage is one is physical. Suppose because of this, there was a duty dereliction, there was deficiency in duty, there was a direct cause also, and that resulted into damage. That time only the court will hold the doctor negligent unless all the ingredients, these 4 Ds should be proved. So it is known as these are the all elements. If the patient want to succeed in his claim, the onus is on him to prove that all 4 Ds are present. Now we will come to the reasons for litigation. Why medical litigation starts? There are a number of, you can see this delay in treatment, and you correlate with 4D. Then you will understand. Delay in treatment, the consent, hospital front office, bills. Bills, yes. How bills is also, will it come in medical negligence? Yes, bills will also come in medical negligence because of some unethical practices or some unwanted procedures or some exorbitant charges. You can see in the COVID, there were hospitals are levying exorbitant charges, and there are many. Still, we have not received any litigation of COVID, but definitely, certainly, few may come up. Then the investigations, proper investigation should be done, or there are delay in the investigations. I will tell few examples also. Then the referral. The first instance I told, if he is an MBBS doctor, he will examine the patient. Suppose one pregnant woman will come, she had fits, she may be going into eclampsia. So at that case, the duty of a family physician, even though he has a hospital, he cannot assure I will conduct the delivery or other, because pre-eclampsia, the hypertensive pregnant woman, they will land in some complication. His duty is to refer proper gynec hospital. So the referral is also important. Where you refer, you can't refer to physician, you can't refer to a different doctor. So this referral, that is also taken as a wrong referral, is also negligence. Then the issue of medical record also. Many times hospital or doctor will not issue the record because he will be under duress or some tension that something I have done, something wrong has gone from me. So patient may sue me or this will happen. Then the types of medical errors. Yes, the errors, negligence, they all are synonym terms. The types of the errors are diagnosed. It is similar to the slide. I have given some examples also. Diagnosis or evaluation of the patient. For example, missed diagnosis of pregnancy. Many times such litigations we receive. the doctor failed to diagnose pregnancy, wrong test reports also. Then the medical decision making in this immature discharge also. Once hospital will accept the patient, but after that some complication, they will try to shirk away from their responsibility. They try to shift the patient to other hospital also. So the question is why you have accepted when you won't treat. Unless it is dire emergency, okay, dire emergency should be treated by each doctor, whether he is a specialist or not. The basics, the first aid and the emergency first aid should be given by each and every doctor. Then the treatment, waiting when treatment is indicated. Suppose treatment is acute appendicitis. Some terminology may be difficult to understand you. Acute appendicitis or acute cholecystitis, gallbladder stone. The pain is severe. Acute appendicitis, pain is severe. The patient or the child or the woman will be brought to the surgeon. He will diagnose, yes, it is the case of acute appendicitis. Then if patient was kept in waiting without doing any investigation, if the appendix burst open, usually it burst open, and she will land into peritonitis and die. So that death, it itself res ipsa loquitur. The things speak on itself. I will come to that. So waiting for the treatment when indicated, when it is indicated, suppose the cancer patient is there. Cancer patient, it should be given either radiation or chemo or operative. You tell him, just keep on waiting. He will develop metastasis and die also. Then the medication, incorrect dosage. Yes, incorrect dosage, it is important, especially cancer patients. The chemotherapy dosage is very important, and many litigations on incorrect dosage, because if the dosage is increased, patient will succumb very fast. Then inadequate supervision. Yes, this is also complaint. Patients, they complained that no doctor, no nurses visited me for throughout a day, and the patient developed complications when there was a bleeding also. No urine passage. So these are all the follow-up is necessary. Then the faulty communication. It is known as doctor-patient relationship or doctor-patient communication. Many times doctors in OPD, they will give one prescription. Go and do this test and take these medicines. The illiterate patient or literate patient will bring the medicines, and it is duty of doctor or doctors, the staff of the hospital or the OPD, the consultation staff, to explain the patient how the dosage to be given, how the tablets should be taken, whether he has brought correct tablets or not. Sometimes the pharmacist will give anti-diabetic medicines, and they are very harmful. The patient may develop sudden hypoglycemia and he will die. So this is a proper communication between doctor, patient, or the hospital or the consultation staff with the patient is very essential. Then the procedural complications, faulty technique and other, yes, these are known. Now the informed consent, I am dealing this informed consent in subsequent slides. Now we'll see what are the obligations. When the litigation starts, what are the obligations? The obligations now, obligations, who will file the complaint? How the litigation starts? The aggrieved patient or relative. He will approach the doctor or his best friend. He will approach the advocate or his best friend and discuss. So I have gone for this and this happened, this complication occurred. So what to do? Then the case will be prepared along with the documents if available. Many times doctors fail to give the medical record. That time he has to approach the hospital again and apply and ask for the record. That time, even that time also, hospital will not give the record. This will be the another ground to file the complaints also. Then depending upon the jurisdiction, the cases are filed in district commission, state commission, and national commission. This is the nomenclature in the new Act 2019. So what is the jurisdiction? I think our Honorable President, Justice R.K. Agrawal sir, and Dr. Ashok Patil also spoke on this, the new Consumer Protection Act. Now, the jurisdiction of Consumer Protection Act, now 2019, remember there is a lot of confusion whether it is a consideration or the amount claimed. Remember now the new act, it says consideration. If the consideration is paid more than 1 crore, below 1 crore, it should be in the district commission. If the consideration more than 1 crore to 10 crore, it will be state, and above that, the complaints will lie in the national commission. So it is not on the claimed amount. Previously, it was claimed in the previous act up to 20 lakhs, district forum up to 1 crore, state and above 1 crore claims. Now it is not claimed. Then after filing the complaints, the preliminary hearing will take place, and the complaint will be admitted if it is a prima facie appears to be some element of negligence. Then the notice to the opposite party will be sent by the commission and giving opportunity to defend the case or file the written version. And in the new act, I think section 34 or 38, in the previous act, it was 13 to file a written version or reply within 30 days. Remember, this is the very strict. If you are practicing advocates or you are defending the doctor, that time, this 30 days is very important. If you won't file the reply within 30 days, your right will be forfeited. Plus 15 days extension is there. The Honorable Supreme Court judgment, recent judgment on Hilly multi-purpose case, it categorically told if the written version is not filed within 30 days, plus 15 days, extended 15 days with the request, then the right to file the written version is forfeited. The doctor has no defense. He has to argue on the legal issues only. He cannot take the evidence on the, he cannot file evidence also. This is the obligation of the doctor. Now in the medical negligence, we have to see some elements. What is the duty of care? Duty of care is when the doctor's duty starts. We saw medical negligence first is duty, then duty of care starts. When you have duty, then the duty of care will start. When the patient goes to the doctor, when he enters in the chamber of the doctor, the duty starts. Then that is the duty of care and caution from him, which is implicit. When there is a duty, he is cautious about, that is the implicit duty, caution also. The doctor cannot escape from the liabilities. Remember, I have done my duty, but you cannot escape from your liabilities. There is no excuse that he acted best of his abilities. He cannot, when you have duty, you cannot shirk away from your liabilities further. If there is wrong, definitely liable. No excuse, you have done, I have done everything best, but this was missing from me. No, it is not pardonable. Then his act was, and what law expects from the doctor, it should be reasonable duty of care should be there. Yes, again this, when the duty of care starts, the doctor-patient, when the doctor-patient relationship starts, just I told doctor-patient relationship, doctor-patient communication, it is very important. Once the doctor begins the treatment or once the patient enter in his chamber, the duty is there. It is a implied contract. Doctor has accepted the patient and patient accepted the doctor. Yes, you can examine me, you can check me. So once the doctor begins the treatment, the relationship starts. When the hospital relation will start, the hospital relation will start when the patient got admitted. But remember here, in the emergency circumstances, the duty starts when the patient present himself at the emergency unit, even he is before the consulted the doctor also. Patient will be brought to the hospital in the emergency. When he enters, the hospital's duty starts from that point of time, not from the time of admission or doctor will check and the other thing. No. Now the other element is second is dereliction. Dereliction is breach of duty of care. If the doctor or hospital failed to provide proper care. Second is delay in investigation. Yes, we have covered it. If the care is provided not up to the reasonable standard, then this is also a breach of duty if your care is not standard as a reasonable practice. See here, duty of care. This fellow, the duty is, this is not a duty of care, this is a dereliction of duty of care. So Honorable Supreme Court, it has very clearly explained the duty of care in the Lakshman L.B. Joshi's case versus Trembak Bapu's case, the boy of 20 years fractured leg. In the fracture, reduction of fracture is one of the treatment. Means approximate, they will pull the fracture bones and approximate, that is the treatment. So treat the fracture, reduce, that is no reduction of the fracture. The doctor did not give the anesthetic to the patient. And he gave morphia. Morphia is the sedative. Sedative means patient will go in the sleep. Single dose of morphia. And the doctor, with the help of 3 attendants, they pulled the leg and approximated. Pulled the injured leg and approximated, then put the plaster also. While pulling the leg, the patient went into the shock and died. Patient, because pulling the limb, patient will go into the shock also, neurogenic shock and vasovagal shock also, and instant death of the patient. Then the Supreme Court held this is not a duty of care. This is not a standard duty of care. The standard duty of care was to anesthetize the patient, then approximate the bones. It was held. Then the duty of care from the hospital. This is one of the landmark judgment from our honorable former president, Justice M.B. Shah. Parvat Kumar versus Ruby General Hospital in Calcutta, West Bengal. They have quoted, can doctor insist and wait for money when the death is knocking the doors of the patient? Obvious answer is recovery of fees can wait, but not the death nor the treatment for trying to save the life. Here in the case, I think this is the case of acute appendicitis, and the hospital was insisting you deposit the amount, then only we will treat you. But by that time, the patient succumbed. So the hospital duty, emergency duty starts when the patient entered in the hospital. Then the proximate cause. Just I told that the action of the doctor should result the injury. If his action, if there is negligence also, if it won't result in injury, it is not taken as a negligence. The patient who adversely affected by treatment has to prove. Now, this is the duty of patient to prove it was a proximate cause of my injury or my defect, my damage. There was existence of duty of care. See, patient has to prove that this doctor was bound to do this thing. It was mandatory for this doctor to do this thing. There was an existing duty of care. Then second, the breach. The breach has occurred. Because of this breach, the patient suffered. He cannot correlate with some other things and bring it and show that this is also due because of the doctor. It is not the thing. Sometimes it is very difficult to prove causation also, because many patients, they don't know medical knowledge, don't have medical knowledge. So it is very difficult for the patient to prove the causation. So if in such case, what to do? Whether patient has to, he is remediless? No, it is not remediless. Patient patient will seek the expert opinion. Now the question, expert opinion, he will never get, because we observe no doctor will give opinion against other doctor, or he will not comment, or he will not give anything in writing against the negligence also. So that time court will appoint the expert medical board, or court will refer the case to the expert medical board. Then the another terminology which you should remember is standard of care. If the doctor fails to attend the patient, yes, it is also patient is admitted with the pain in abdomen or fever, high grade fever admitted. He will not attend the patient. Then the patient will go into the encephalopathy and die. So not attending patient in proper time is a negligence. Provide quality and suitable treatment. And hospital is also under obligation to provide skilled manpower also. You can see the example, the inexperienced junior doctor by mistake inserted a catheter into the artery. It is a cannula, not a catheter. It is a cannula into artery rather than vein, because cannula is inserted in vein, but accidentally it was gone into the artery, radial artery of the hand of the infant. Hand means this is the hand, in the radial artery of the hand. So the child subsequently developed ischemic gangrene, the death of the lower part of the hand, and it resulted in amputation. So it was held negligent. There are two similar terminology, standard of care and degree of care. The standard of care, it remains constant and same in all over the world. Remember, standard of care is, it remains throughout the world, it is standard of care only. But it should be reasonable also and need not be highest degree. The standard of care is examining the patient. So for example, one heart chest pain patient will come to the doctor and he will say, I had severe chest pain. If he is MBBS, if he had ECG machine, then the standard of care is he should take the ECG. Or if he is physician also, if it is a hospital also, if the patient with chest pain comes, your prime duty is examine and take the ECG. ECG is a standard of care throughout the world. You cannot see and, oh, he has heart attack and give these tablets. Read the ECG. Standard of care is reading the ECG, you should read properly. That is the standard of care. It is a universal. Then what is degree of care? The degree of care is variable and depends on the circumstances. Degree of care when starts, if the doctor took the ECG and if he finds, yes, nothing is there, then the degree of care will start. No, this patient is different. He has some gastric perforation or gastritis or acute pancreatitis or whatever. There are a number of reasons for the chest pain, left side chest pain. If he has to rule out with the standard of care, the ECG was normal, then he will further, degree of care will start. Whether shall I treat the patient conservatively, shall I operate him, shall I tell him go back or whatever, that is the degree of care. So how the court decides the standard of care? The completing the evidence. It is a specific, court will go through the evidence. Then the general competency of the doctor, whether good clinical or ethical practice and whether he is competent to do that. Then the respectable minority standard, it is the Boehm's test. It is a very exhaustive test, and this is Boehm's test. You can download and read the Boehm's test. With the Boehm's test, it is, I think, in 1952. Boehm's, the principles are fixed on the reasonable and standard of care is decided by the Boehm's test. It is there is a minority. Minority means, suppose there are few doctors, there are 10 doctors. If the 2 doctors are also telling, no, this is accepted practice, sometimes it is accepted practice, that time minority opinion also withheld. yes, this is the reasonable standard of practice. It is exhaustive judgment, just go through. If time, then the reasonable man standard, duty of care, and check the judgment standards, because the commission, consumer forum will arrive whether that doctor was reasonably, that treatment was reasonable, or there was a standard of care. And the practice parameters, there are guidelines. SOPs means standard operative guidelines, which are prescribed by medical council, and there are different societies, medical societies, whether doctor followed that or not. Okay. Now, who is liable? The case is there. Now, who is liable? Because many times patient don't know. Patient will say, I went to that hospital. So some doctor checked me, and after that they admitted me, and the relative will tell, and finally he died. He can't pinpoint the name of the doctors also. So that time, who is liable? He will say doctors have treated. Then hospital has duty to provide the names of the doctor who treated. Now, if he is a private consultant, he is a private clinic, private nursing home, that time he he himself is liable. There is no question of under any hospital he is working. So it is known as contract of service and contract for service. These two terminologies, the two sentences are confusing. Just go for the contract for service is the doctor. I am an independent doctor. I examined this patient. So I am only liable for this. Any wrong committed by me to the any liability of paying compensation. Suppose I am working in some hospital, private hospital or corporate hospital. It is a polyclinic run by some partners, and that time that hospital is also liable if I commit any wrong. Definitely I am also liable to the extent of certain extent, but vicarious liability will be fastened on the hospital. Most of the time, the courts will fasten the liability. Major chunk has to be compensated by the hospital. That is known as vicarious liability. That is employee-employer contract, because master is responsible for the act of the servant. It will not come here. Suppose the surgical team is there, surgeon is operating the patient, and if the sister will, by mistake, wrong will committed by the sister, or after the operation they will close the abdomen and some swab or some scissor will be inside the abdomen. Now surgeon can't take the ground that sister, I finished my operation and cleaned, I finished my operation, but the sister failed to make a swab count. Swab count means how many swabs before operation you took and how many swabs are present after of the, or even instrument also, how many instruments were there, they will count after operation. Yes, they are equal equivalent. So doctor cannot take the defense that sister missed that. It is not. The master is liable, vicariously liable. The surgeon is not, I will tell vicariously, the element of vicarious will come, that principle. Yes, I told before the thing speak on itself. So I think I have 15 minutes more. I will finish. The things speak for themselves. The facts speak for themselves. What it means? It is a maxim res ipsa loquitur. It is not a principle of liability, but it is a rule of evidence. It is not principle of liability. On this, court will not fasten the liability. It is a principle of a rule of evidence. Suppose you have to operate on the right hand. Accidentally, left hand will be operated. Many times this happens. So this is the res ipsa loquitur. This can help patient in situation where cannot specify what exactly caused injury. This is the best remedy. This is the best thing for the patient or the complainant to prove his case. Now what happened? Suppose res ipsa loquitur is there. The doctor has to prove his innocence in this case. Some cases we got there is severe bleeding after operation, severe bleeding. The artery was cut. Because of the severe bleeding, patient died. It was a frank case of reciprocalocator. How to prove? In the post-mortem, it was proved the artery was cut. So doctor has to prove his innocence. I don't know how it cut, but it is very difficult to prove the innocence in the reciprocalocator case. Yes, now the consent, I told, it is very, very important aspect, consent in the medical practice. Most of the cases of medical negligence are filed on consent only. And most of the complainants or patients' first allegation is the doctor not taken any consent before operation, before procedure, before treating. So remember, if you read any judgment of our National Commission, most of the judgments are on the consent issue. What is consent? Consent is required by law. And for patients' autonomy also. It is for patients' autonomy. Patients have every right to decide what happened to their own body. Remember, doctor cannot touch the patient's body unless there is a consent. But the implied consent, implied contract, which I told you, when the patient approaches the doctor's consultation chamber, that time that was the implied contract. Now, when the consent starts, the patient agrees. Doctor will say, I want to examine you. Then patient say, yes. This is implied consent also. Implied, or the doctor has asked the voluntary consent. The patient, especially if the lady patient is there, that time the law mandates one lady attendant should be there. So if it is the case, this is the consent implied. Where we are, I will explain what is informed consent. In the law, informed consent is very important. An essential prerequisite to commencement of any medical treatment. Without such consent, the treatment of patient would constitute trespass or battery. And patient has every right to refuse his treatment, provided adult and sound mind. This is the doctrine of consent. What is the doctrine of consent? Just I told, every patient has a right of self-determination and personal autonomy to decide what shall be done with his own body. A fundamental aspect of right to health, the basic principle which permeates through all the cases. The reference, you can read this, you can download from our website. This is very good judgment of HIV. What are the types? Different types of consent. Express consent. Yes, patient will verbally or tell in writing also. Yes, doctor, you can examine. Implied consents. It is the behavior. Doctor, behavioral. Yes, doctor will say, I will examine. Patient will say, it will not say no, or patient will ready for examination. Then the valid consent. Valid and informed consent, both are nearly same. I will go to informed consent just further. Then the proxy consent also. No, the parents are not here. So the patient's relatives are not here. But if it is emergency also, that time on telephonically consent will be taken from the parents or relatives also. Yes, now the informed consent is very important in the legal domain. If you are practicing advocates also, remember this is very important. Make it thorough from your end. It is whether signatures on dotted line is consent. Many times we come across such agreements, bank documents, many things, LIC policies. We don't know what is written there, and we just blindly sign every small letters. In the hospitals also there are consent forms. So on the dotted line, whether signature on dotted line is a consent? No. Consent, what is informed consent? Informed consent, its patient should be explained each and every aspect. I have quoted further the I have explained it very nice and neatly in the next slide. So what is informed consent? There should be disclosure. The doctor should disclose what he is doing. Then the degree of disclosure now, doctor, he has duty. Suppose doctor see and yes, we are going to operate you, or these are the medicine I am giving you, and you may die also after taking this medicine. If you say like that, the patient will be afraid. This is not the way. So which percentage of disclosure you have to make, that is also important. So reasonable disclosure depending on the case, then the adequate disclosure and complete disclosure. What is complete disclosure? If the patient is of frank cancer, all metastasis means cancer has spread in the body, and that time doctor has to disclose because of this chemotherapy. He has to disclose everything. You will lose your weight, you will lose your appetite, you can't sleep, you will lose your hairs also, the burning also, you may develop, you will land into severe weakness, there will be blood loss also. This complete disclosure should be there. Only nothing will happen, just come, will you start chemotherapy? No, there should be complete disclosure. Tell the patient this will happen, you will die during the chemotherapy also. Then let the patient decide whether I should go for that or not. It is his outlook. So this is a complete disclosure. Now, what is again how detailed consent should be? It is again patient or attendant should be able to make a judicious decision based on the information shared by a doctor or the hospital or the treating member of the team. What happens usually, what we saw in the commission also, where in my bench only maximum medical negligence cases are listed, and we and our judge brothers, we decide the case. Many times doctor will say we have explained everything, the risk, but we see they won't document what they have told to the patient. Documentation is very important. The consent form should be filled in each and every aspect. If it is not there, then it is taken as no consent or negligence also. Yes, I was telling informed consent. This is the short form. What is informed consent? It is doctor has to explain benefits of the treatment, risk of the treatment, then alternatives of treatment, and also whether doctor has to tell the patient there is no treatment at all. There are certain diseases, no treatment at all. Nothing will happen, there is no treatment, or you will die after few years. This is, he has to tell, despite if I treat also, you will die, he has to tell risk of. Then the documentation, it is very important, documentation and signature, because everything, whatever the doctor has done, he has to record that. Samira Kohli's case, yes, you can go through, our Honorable Supreme Court has elaborately discussed about concept of the informed consent. Then the Montgomery's, very recent case of Montgomery's in 2015. So these are the few cases how the consent, historical evolution of the consent occurred. You can take this picture and you can go through this. This is our recent judgment, the last 2016. Honorable Justice Jain's judgment, or Honorable President, past President. So I think I am within time, and we'll have discussion. Any questions? I am ready, certainly happy to answer your questions. Just thank you very much.
Thank you, sir. We have a few questions from the participants. So
Yes.
the first question is,
shall I minimize? Can I stop the sharing now?
Yes, sir, you can.
Okay. Yes.
Sir, so the first question is that, as you said, common person does not have medical knowledge. So how does he know when his right has been violated, as the rooms of care such as ICU or ICCU are inaccessible by the common man?
Yes, now see what happens in the OT, operation theater or ICCU, when he is not accessible. See, his allegation, he has every right to make the allegation. He will file the complaint. Now you are asking how he will prove when he is outside the ICU or outside the operation theater. Now the onus shifts the burden of proof and onus of proof. It is the thing. The patient will say, the complainant will say, my patient was taken into the ICU and I have doubt they have not done the ECG or they have not treated, they have not given this injection they would have given, they have not done this procedure. So for draining, or the patient has loss of urine, patient was unable to pass the urine. That time the doctor or ICU staff should insert the catheter. His allegation that they have not inserted the catheter or they have wrongly inserted the catheter. That's why the bladder was ruptured. The case of bladder ruptured, and now patient is outside the hospital. Now patient proved his case, not proved his case. His burden, this is onus. His onus, he put the onus that, see, my patient was taken inside and the catheter was wrongly placed. Now it is the duty of hospital and the doctor. It is the burden of proof. The burden of proof shifts on the doctor that we have done everything. Now there is no need for the patient or complainant to prove his case. Further, doctor has to explain that I was innocent. I have done this. How he will make it then the medical record. They should record, yes, this happened, patient suffered this, then we did this, then this. If there is no medical record, then nothing will be helpful. Remember, if poor record means poor defense, no record means no defense. Court will directly conclude. Only verbally he will say everything, but actually whether it has done or not, unless it is recorded. But most of the doctors, I won't think any doctor will do negligence intentionally. But sometimes mistakes happens. So because he has not recorded, then or some nursing recorders are there, he has to prove. The burden is on doctor. Yes. Any other question?
So then there's a question that what are the laws and the procedures in case of voluntary euthanasia?
Voluntary euthanasia, it is we are going away from the subject. It is not under consumer protection. Euthanasia is very vast. Voluntary, what you ask? Voluntary?
Voluntary euthanasia, the laws and the procedures in case of voluntary euthanasia.
You refer recent judgment of Honorable Supreme Court. I think that Bombay nurse case. Anuradha, I think Anuradha.
Aruna Shanbag's case.
Aruna Shanbag, because euthanasia, let us not discuss at this point.
Okay, sir. Then there is another question that when a doctor is taking consent for a life-changing surgery from the family, for example, accident cases, the family or the medical proxy may not be in the right state of mind as they are in grief and their decision may not be the best. So how is that consent valid?
See, now the consent should be given by either patient or his near relatives or his best friend or nobody. This is the thing. When nobody, if it is a dire emergency, doctor has to proceed further. No need of any consent. Okay. Then the second is you are asking the patient relatives are in dire stress.
Yes, sir.
It is not the ground that somebody, all are in grief. Grief is not the defense for not giving consent. Grief is not taken as the thing. Then the doctor has to record that they are not willing, but the patient was sinking. Therefore, I have to take the decision and I got operated to save the life. That is the best way doctor's defense is that. That time court will also examine whether it was emergency and the doctor did correct thing. Suppose patients, they are in agony and doctor will keep watching and the death of the patient occur without treating. then how it is sustainable? So it is absolutely wrong if the patients are behaving like that. And it is a doctor record that with the one witness or with the help of other colleague doctors or anesthetist or anybody, because team of doctors, they will record and proceed further. Court will not hold them negligent. Yes.
Okay. And sir, there is a question that what is your opinion on the Ayurveda doctors performing the surgeries?
Right now, no comments on that.
Okay, sir. I guess that's all for the.
No, I have a question, sir. I am Rajan Singh from Bombay. Can I ask a question, sir?
Yes, yes, you can.
Sir, as you rightly mentioned, that the consent is necessary. And once consent is taken, then doctor has completed his or her work. If consent is not there, and then it is up to doctor's judgment what to do with the patient. But
Yes.
sir, even in my personal capacity, when I have gone to various hospitals, the papers they give for signature, suppose my child or my wife, she is the patient and I have to sign, or suppose I am the patient and I have to sign, all those papers or so-called consents are heavily loaded in favor of the medical facility and heavily loaded against the patient or the patient's relatives. So A, how to handle that? So this is my one question, sir. The other question is that 100% Indians may suffer from health reasons, and it is a question of life and death. Something may happen with the part of a body, or overall life or death or disability, etc. And consumer forums are basically there to judge A, if any injury was done, and B, to compensate that monetarily. They cannot go beyond and do anything else. And let's accept it that they are not specialists, whereas the medical field is very, very specialized one. So in that situation, how consumer forum should work, and should we have a special body like ADA is there in insurance? Insurance cases can also go to consumer forum, but government of India and our nation has IDA. So they decide the insurance cases right from beginning. What kind of form should be given, how a particular policy should be administered, what details should be given, how the promises should be made, etc. So what are your, sir, larger views on this?
See, the first I will answer first how to handle such consents. Okay. Now the hospital, they have prepared number of pages, or some hospitals have booklets of the consent. Because consent now has taken the prime role in the medical negligence cases, and hospital, they want to be safe on their side. Now, as a patient or patient's relatives, it is a mandatory, they have to go through each and every word also. For example, the bank or some agreement or anything, we also sign. I'm not telling that, because signing the consent means you have gone through everything. Now, whether it was informed consent or not, that is very important question. Now, suppose the consent form won't contain all ingredients. Suppose there is one specific operation. Suppose one pregnant lady is going to the one hospital, and the consent, that booklet consists of everything. But it has not explained the complications of pregnancy or delivery, or what are the different methods of that, seizure or whatever it is. If that form or that bundle is deficient about, or it has not included all those ingredients, that time patient has chance. Now, you cannot take the defense that there are number of pages and how can I handle this. It is definitely it is a responsibility, because hospital is doing its duty to take, and they will inform. You can, the patient can take the ground that they have not informed us. They have taken just signatures on each pages. That is the responsibility of the patient to prove that, because now most of the doctors, most of the hospitals, they are explaining the patient's relatives by audio visual also. They put the one video or one film show also. Yes, we are doing your this operation, and entire thing is video recorded also. That's why then the patient will definitely sign the consent. If it is not done, then patient has to prove they have not explained me anything or just taken on the paper. This is the one thing. Second, you asked regarding what you asked. What was?
Yes, yes. The second point was that medical facilities are needed by all Indians and they have huge implications. It is not a small loan here or there or a product which has gone bad and therefore compensation has to be taken. So consumer forum are adept at.
I am answering that. I am answering that. Your another thing is consumer fora should have some medical like IRDA and other things, some medical board or something help of assistance. Yes, I agree, because most now the medical negligence cases are rising, very rampant rising trend is there. First thing. Then I agree that consumer fora, all the members or judges, they are not well versed with the medical knowledge. Now, if they are not well versed with the medical knowledge, it is not the ground that everywhere doctor should be appointed. Now, the provision is there, the court now there is a provision, the consumer commission can refer the case to the to formation of expert medical board, either any good hospital, government hospital, or preferably medical college. So in the National Commission, we referred the AIMS or Safdarjung or Maulana Azad. Any reputed medical government college, you refer the case along with the file, with the evidence or the medical record, and request the authority to constitute the board of medical expert in neurology, whatever the case, depending on case, or leave it on them, they will constitute the board and give the opinion. This is the second thing. Now the question is, if the medical, there should be one separate body. Now the MCI is dissolved, now National Medical Council has been established. I think government may think of forming the national body also. The cases may go there and come to district, the commission also. But it is the domain of the government. The representation from the doctor society should go there. Or the other way is medical boards. Courts are taking medical opinion from the medical boards also, either civil courts also, civil courts, high courts also taking. So there is no need for in each consumer fora such a medical expert be there. There are very few people in India working in consumer courts or consumer state commission. As I know, in Bombay, in Maharashtra, Dr. Kakade is there. Here I am. So we volunteered and we joined. That's all. But in district forum, tell me which doctor is ready to come. Doctor, he don't want to spend time there because it is difficult for him. So that's why it is a question of the government policies. This is the thing.
Sir, in first case, as you mentioned, that consent, once it's signed, then it is assumed that a person knows everything, etc., etc. But the medical institutions or the hospitals do not like and do not allow any change to be made. Suppose there are 1,000 lines written and I have been informed about the medical institution, about all the consequences, and I wish to disagree with one clause or one sentence, they will say, you go, we will not handle if you make any changes in this. So it is not an informed decision, it is just a forced decision or consent.
Yes, tell me. Yes, the hospital will say they won't change. See, hospital has certain policies. They will say there should be acceptance. Now, if you feel they are blackmailing me, and then you can reject. And hospital and doctor has every right to reject the patient also. They are not forcing, because there should not be force. If you are agreed with this clause, you delete and you write in your handwriting. I don't agree with that. Let the ball roll in the hospital. If whether they take you or not, they will say you, okay, we will not operate you, go to other hospital. It is not negligence, it is a hospital policy. How you will force you operate me? How the patient will tell no without, unless it is emergency, how they will accept? They have every right to reject the patient. Yes.
Thank you, sir. Thank you. Thank you.
Okay, thank you, sir. On the behalf of Navratna University, I would like to thank you for sharing your valuable insights from both medical and legal perspective. Using simple terms for explaining technical aspects have benefited to all of us. Thank you, sir, for giving us your precious time.
Thank you very much. Thank you for all, Dr. Your principal, Dr. Sujata Patil, my professor, Dr. Ashok Patil, my friends here. Thank you.
Sir, thank you. Sir, on behalf of Navratna University, all my faculty colleagues, students, really it was a very insightful session. Thank you so much for coming and being with us and sharing the valuable inputs.
Pratima ma'am, are you ready?
Yes, I'm ready.
Yeah, good afternoon, ma'am.
Good afternoon.
Nitya, please take over.
Pratima, your voice is low.
Arush, your voice is low.
Is it better now?
Yeah, Pratima, madam.
Can you hear me?
Ma'am, you are really inaudible.
Can you hear me now?
Yes, ma'am, we can hear you, but voice is very low.
Is this better?
Yes,
Yes.
ma'am. Now it's clear, ma'am. So Nitya, please start.
Yes. Good evening, everyone. We extend warm welcome for technical session 4. It's an honor to have with us Dr. Pratima Narayan, ma'am. Ma'am is an advocate, mediator, founder partner of Technology Consultant LLP, a law firm based out of Bangalore. Her expertise lies in the area of information technology law, intellectual property rights, commercial contracts, consumer law, and alternate dispute resolution. Dr. Pratima holds a doctorate in law from National School of Law, India University, Bangalore. She has published several articles which have been published in national and international journals, and also has served the legal academia for over 2 decades as a visiting faculty at various reputed law schools and business schools. She has authored a book on electronic commerce, legal compliance, published by Eastern Book Company. She is an editor and consultant at EBC Learn. Ma'am is an executive council member of CII India Women Network. She is co-convener for the wing of gender parity of Karnataka. She also serves as a governing council member as Consumer Care Society, a consumer NGO engaged in consumer activism. She is a mentor on board of managing committee at AMC on NGO supporting person with intellectual disability. I request ma'am to take over the stage. Welcome, ma'am.
Thank you, Nitya. Thank you for the kind introduction. And at the outset, I would like to congratulate the School of Law, Navratna University, to be conducting this national webinar on consumer policy, consumer protection law, and the reforms and the various reforms in association with the Chair of Consumer Law and Practice, National Law School of India University, with which I have a very close association with Dr. Professor Patil. Thank you very much. This has been a wonderful opportunity to interact with you all and share some of my thoughts on the subject of e-commerce. I will just, with your permission, I'll just share a small presentation with you all. Of course, the last bit of the presentation where you've all gone through a lot of interesting sessions from the morning with regard to the Consumer Protection Law, the Consumer Protection Act of 2019. And I was also sitting through the medical negligence program, the seminar session, the technical session, which was very, very insightful. And now we will just move on to another very, very important part of the consumer protection law, which is of paradigm importance, which is of great importance in the present context in the digital age. So I have a small PPT. If you can see this, are you able to see the PPT?
Yes, madam. Yes, ma'am, it's visible.
Yeah. So, as always, I would like to begin with a few numbers of what is the e-commerce trend today? How is India progressing with this particular segment of the consumer transactions? As far as the e-commerce market is concerned, what we see of today is that there is a huge revenue of something like 46 million US dollars, which is a huge amount of transaction that happens day in and day out, with the user base being something like 548 million as per the most recent statistics, which is brought out by Statista, which is a survey organization. So this is the large volume of user base we have as far as the digital transactions and e-commerce is concerned. According to a more recent news, by the CNBC, as per the National Consumer Helpline, there have been at least reported cases of 1 in 3 complaints which have been relating to e-commerce. So if you see the statistics here, it says in June, out of the 45,446 complaints that were received by the National Consumer Helpline, about 14,480 cases were only of e-commerce. This is the number of complaints that we have been receiving, and this is only one small component. That is, it is only the statistics of National Consumer Helpline. But apart from this, there are perhaps a lot of consumers who are complaining to the e-commerce portals, and they're trying to seek a remedy from there. Or they may be complaining to certain NGOs, and the NGOs may be trying to help them and coordinate with the e-commerce portals to try and see how they can resolve the dispute. So these are all at the base level that they are trying to do. National Consumer Helpline, and of course they are also moving the courts, the district forums mostly, because they are of small claims. So a lot of them have been moving the consumer courts as well. I don't have the numbers with me right now, but this will just give us a brief overview of what is the volume of cases that we have to address as far as e-commerce is concerned. So this also brings us to an understanding that it's now high time that we have to address this particular sector as any other sectors like insurance or medical negligence or maybe banking or whatsoever. Of course, talking about e-commerce, and especially in this time of COVID, where we have all been experiencing some form of the online transactions or the other. We have been trying to procure food, we have been trying to procure services of different kinds, we've been trying to procure medicines also through online. And this is the most recent area that they have come up with, where even pet care industry has come into the online space. So even our pets will now start receiving goods and services from the online space. So this is like about 2 days back that it was posted that its recent pet care industry has also started. So there is literally nothing, there is no segment, there is no sector which is untouched with e-commerce. So everybody have been using the digital space. Given this, what are the kinds of consumer complaints? They are either transaction related, where we have had some issue at some stage of the transaction, maybe a twice payment when we were placing the order itself, or we received the product was not good, or I want to return the product, they don't have a good return policy, the product is bad, or whatsoever it is, or I returned the product, but it has not been refunded to me. See, these are all some of the transaction related issues that consumers have been complaining about. While that is one part of the complaints, the other part of the complaints which e-commerce companies will also have to look into are the online frauds that take place on their platform, especially the marketplace models. I'll talk about the different kinds of models through this presentation. Now, coming to the online frauds, what are those kinds of frauds? Number one, sale of a lot of counterfeit products. This has become a hub because the sellers can just sit behind this platform and sell whatever they want, right? So that is one thing. And online payment frauds, that is another area, that is another world in itself. Of course, we may not be able to touch upon too many of those aspects in today's session because the focus will be on what are the reforms. But we can list out a number of such situations where online frauds have been taking place and consumers have been deceived in very many number of ways. So this being the ground for the consumer protection reforms to come into place. So these were some of the reasons why we had to look for some kind of reform, some kind of enhancement of whatever was existing in the present, in the earlier Consumer Protection Act of 1986, and what we had to address. Number one, the large customer base, for which there is a need for more reforms. And a need was felt because there was increase in online malpractices. And thirdly, the virtual nature of e-commerce itself. The very architecture is like this, where we don't face there is no human intervention at all of the seller, buyer, or even the platform. So that is the reason why we need to step up a little further ahead to try and see how we can bring a level playing field between the physical systems of an online, a regular offline store or an offline service vis-a-vis the online services or online procurement of goods. So this is where the need was felt that we should have some reforms in place. We should step up in the Consumer Protection Act to try and address these situations. We will now move on to see some of the changes that have been brought about, some of the important provisions in the perspective of e-commerce and consumer protection. The very first thing is the definition of e-commerce has been brought into the Consumer Protection Act. The definition goes something like this. It says e-commerce means, I will just read this out. It says e-commerce means buying or selling of goods or services, including digital products, over digital or electronic network. So this has been the definition now. We have three elements here. Number one, we have goods, which has already been defined under our Consumer Protection Act. We have services, which are also defined under our Consumer Protection Act. So anything which is in the form of a service which is available online. So you may be booking your online movies. You may be booking air tickets, or you may be booking, you may be procuring any such things from the online services. So that is also included here, or online education, online learning that we are procuring today. We are availing so many courses through the online platforms. So that may be one of those. The other thing, the third category that has been introduced today is what we call as digital products. Digital product is a very, very important aspect which has been introduced, where it doesn't actually fit into the two categories, which is the reason why we have a third category today. Our consumer forums will henceforth start to decide on a lot of disputes where it is based on the digital product. Digital product is nothing but there are subscription-based procurement of services. Now, for example, if I have procured, online books, or if I am going to procure online music, online games, there are so many online games that we purchase today. So all of these are worked around a digital or an electronic network. So these kind of products, they are very unique because you need an internet connectivity. You need the information and communication technology to make use of these goods. So henceforth, we will have a lot of disputes in relation to the digital products itself, of in terms of the subscription fee, in terms of some of the issues that they had with respect to licensing or whatsoever it is. So we are yet to see a lot of disputes in this particular space. So we have goods, services, and digital products which have been brought under the definition of e-commerce. And then all those who are providing this service of e-commerce for the purpose of Consumer Protection Act have been defined as electronic service providers. It has been defined again under the Act. It's been very clear. It says electronic service provider means a person who provides technologies or processes. And this service provider enables a product seller to engage in either advertising, selling goods or services to consumers, and it includes online marketplace and online auction sites as well. So all of them who are providing these services fall within the category of electronic service provider. That has been very, very clearly defined under the Consumer Protection Act today. Apart from defining what what is e-commerce and who is an electronic service provider, we also stepped up a little to make it explicit and very clear that whether it is an offline transaction or an online transaction, the person who has been carrying out these activities, who has availed goods or services or even digital products through any of these medium, should be regarded as a consumer. Earlier in some of the decisions, and one of the NCDRC decision itself in 2012, there was one issue that had come up saying that a person who had procured some commodity from the online store, that the e-commerce company had tried to convince the court saying that we don't get anything out of it. It's only, we don't get any sort of a payment made by the consumer directly. So we don't fall within the ambit of consumer since there is no consideration to us. Wherein the NCDRC back then in 2012, in a case that was Rediff.com versus Urmil Munja, they made it very, very clear that e-commerce portals are not charitable institutions, and there is a commission that they get for each of the product sale or the service that they provide, and therefore the person procuring goods or services through the platform is very much a consumer within the ambit of the consumer protection law. Of course, the court had to intervene for the purpose of interpretation, and today this has been solved. This problem of identifying whether he is a consumer or not has been very, very clear to us through this definition of consumer. This is very, very important. So if there are students, I would request you to please mark this part of the definition of consumer. Now coming to the different e-commerce models which has been recognized for the purpose of various enactments, including the Consumer Protection Act. So basically all these activities of e-commerce have been bucketed under two categories. Number one, we call it inventory-based model, and the other is what we call as market-based model or intermediaries. So if you're looking at inventory-based models, so you have various e-commerce entities, and even like you see on the social media, there are a lot of them selling their own products online. They sell their own inventory. So either they are selling it by themselves of what they manufacture or whatsoever. So if I make home-based products and I set up an online portal and I start selling these home-based products, I fall within the category of inventory-based model. On the other hand, if I buy a lot of commodities, like how our nearby retail stores do it, right? So they buy the inventory, they buy groceries, they buy soaps, and they buy so many FMCG products, and they have the inventory so that if there is someone who wants to buy that, they will buy it from them. It's exactly the same way which works in this model also, where I buy the inventory and I sell it. So in both these circumstances, we fall under the inventory-based model. Coming to the market-based model, so what happens here is, this is like our Amazons and Flipkart, right? So what is happening here is, it is set up as a platform, it is set up as a facilitator, so that the parties come in, the seller and the buyer come to this particular platform and they carry out the transaction. So basically Amazon and Flipkart and Snapdeal, they are all acting as platforms between the buyer and the seller. So that is why we call it as market-based model. So these are the two important models of e-commerce which have been recognized for the purpose of e-commerce and even in the context of consumer protection today. What are the most common kinds of complaints that we hear? and again, what is it that comes before the court? If there is a complaint, consumer complaint, which has to come before the court, the consumer forums, consumer commissions, what are the different kinds of complaints? So the themes obviously are defect in goods, deficiency in service, unfair trade practice, restrictive trade practice, and product liability. Defect in goods, of course, if there is a manufacturing defect and if there is an inventory who's going to sell these manufacturing defects, or sellers on this particular platform, if there is a defect in goods, they will be liable to it. We all know of it. Coming to deficiency in service, for all the services that are being provided, and if there is probably, they have not provided for that entire year, or for any other reason, if the service provided is they exercise negligence, like for example, medical negligence itself falls under the category of deficiency in service, or maybe in case of any other thing, like maybe a hotel accommodation which was bad, or a travel, an air travel which was bad. So all these fall within the category of your deficiency in service. Likewise, e-commerce platforms which are offering the marketplace, right, in terms of selling these goods, in terms of enabling the sale of goods, they also fall within the category of deficiency in service for one very specific reason. The Consumer Protection Act of 2019 has brought in a very, very important aspect for deficiency in service, which says withholding of information. This is very important from the point of view of information that is to be provided to the consumers. For example, I tell you to refund. I'll tell you that you can send me the product and I'll refund. You send me the product, but you don't know where to send the product, right? So I'm withholding that information. And after that, I tell you that that period of 7 days is over. So now you cannot return the product. So what is happening here is I have some information which I'm not giving you, which is very critical for you to exercise your consumer rights. So that is where the Consumer Protection Act 2019 has brought this very, very important amendment to the deficiency in service, which says withholding of information is also a deficiency in service, which e-commerce companies have to be very watchful about. Then comes unfair trade practice. Of course, we have about 18 plus items which fall under the category of unfair trade practice, like of false representations, or it may be selling a used product as a new one, or misleading statements, or whatsoever it is. And now there are two very important things which have been introduced for the purpose of unfair trade practice, which has a lot of connect with our e-commerce transactions. Number one, it says that if any trader or any business, if they are to refuse taking back the products which have been defective within a specified period of time, there is a cooling off period. And it's as good as saying that if the e-commerce portal refuses to take back your goods, that can constitute an unfair trade practice. And the other important point is, for the first time, e-commerce, the Consumer Protection Act has also brought in the concept of a small component of data protection, where they say that you have to protect the sensitive information of the consumer. I will just point that particular provision out here, which says disclosing to the other person any personal information given in confidence by the consumer, unless such disclosure is made in accordance with the provisions of law. This will be applicable to all industries, including e-commerce, where I may have given in some of my sensitive information, and it is important for the consumer to, it is important for the e-commerce business to also protect it. So that is one more component which has been introduced under unfair trade practice. And of course, we have the concept of product liability. So among the various stakeholders, among the various participants in the manufacture, trade, and final retail of that particular product, even e-commerce companies may be held liable for any harm or injury, the kind of products that are being sold on the platform. So they may also be liable on the grounds of product liability. So these are some of the important themes of complaints we have as under the Consumer Protection Act. Moving very quickly into the jurisdiction part, which has an, I'm just going to focus on that part which has an impact on e-commerce consumers. Of course, we have had the previous, this is with respect to the territorial jurisdiction. The erstwhile 1986 enactment, of course, did provide for the territorial jurisdiction in the context of opposite party where the opposite party resides or carries on business or has a branch office or personally works for gain. It also spoke about where the cause of action arises. But these had caused a lot of discussions, deliberations, and confusions also with respect to what about e-consumers who are sitting across the country. And we don't really, it might not really matter to us where the e-commerce portal is. So e-commerce portal may be somewhere in Noida, and then they may be having a branch office in Mumbai. But the consumers are spread across the country. They are providing their goods and services across the country. So where should the consumer go if there is a consumer dispute? This was always a question. So this part of the territorial jurisdiction has been clarified by the 2019 enactment, which very clearly states that complainant, the territorial jurisdiction would also lie where the complainant resides or personally works for gain. So this is again a very, very important part of the amendment, which would be relevant to and very useful also to the e-consumers today. So where I have purchased the product and where I ordinarily reside or personally work for gain, I can go to the nearest, I can avail the nearest jurisdiction for the purpose of filing my consumer complaint. So this is about the jurisdiction aspect which has been brought in. Due to paucity of time, I will not be going into much detailing. These were the key highlights of the Consumer Protection Act. Now, what has also happened is that the Consumer Protection Act 2019 also empowers, gives certain powers to the central government to make rules with respect to curbing unfair trade practices in the e-commerce space. So there is a particular section. So as under section 94 of the present Consumer Protection Act of 2019 and section 101ZG of the Consumer Protection Act. These are two important provisions which have now given space, which has now led to something called the Consumer Protection E-commerce Rules. Now, this is a very, very important part of the legislation for the reason that this will enhance our consumers' right to be informed. This is a very important piece of rules, a reform that has come into place, which I will just be explaining to you some very, very basic, and some highlights of this because of the paucity of time again. So here is where we, and the most important thing about the e-commerce, the Consumer Protection e-commerce rules is it identifies four players here, four major players. One is e-commerce entities. Then it goes into dividing them under the categories of inventory-based e-commerce models and marketplace e-commerce models. And then it also talks about sellers. What is it that the sellers should do in the e-commerce marketplace? I will just highlight for each, what is it that is required for each of the e-commerce players. Number one, e-commerce entities. It is applicable to all. Anyone who wants to participate in this e-commerce has to follow all these things so that the consumer is eventually protected. We want to reduce as much as possible on the information asymmetry. So what are the important things required here? Number one, anybody who wants to set up an e-commerce entity, who wants to carry out an e-commerce activity should be incorporated as a company. That is very, very important. Second, they must appoint nodal persons or senior designated persons who are resident in India. So suppose if it's a foreign company and they are having their operations in India, if they are selling their goods or services in India, it is also important that they should appoint a nodal person in India so that they can ensure the compliance. They must provide all the information in a clear and accessible manner on their platforms. So many a times we have come across instances where they have just given somewhere in the corner of the website, they would have mentioned, if you have any queries, please contact info@xyz.com. That's all. They have no other information. So I don't know anything about where this business entity is. Or it may be in terms of products. They may have described a small portion of the product, but much of it has not been described. So only thing is they are giving you a discount, a deep discount for which you are interested in buying that product. Or it looks very, very attractive. The product looks just the way you have wanted to procure something like that. So it is very important today that these e-commerce entities must provide information in a clear and accessible manner on their platform, and they must have displayed prominently the name, address, and other contact details. So they have to mention their name, their address, their geographical address, and other contact details. Apart from this, it is mandatory for every e-commerce entity to have a grievance officer. Every e-commerce entity must have a grievance officer. What does the grievance officer do? They receive these complaints of the consumers, and they have to address these complaints. They have to at least acknowledge that they have received these complaints within 48 hours, and they are given 1 month's time to redress the complaint. So everything is time bound now. And of course, it also goes further. If there are importers, they have to name the importer. Very importantly, you cannot have pre-filled checkboxes. I think we all face this problem many a times. In fact, very recently, I wanted to, I procured this antivirus. So sometime last year, there was already a checkbox which said, this year at this time, I have to buy the same. So by the time I realized at 5:30 in the morning, my credit card was used by this particular platform, where the money has gone into that particular company's website, I mean, whatever, the portal, and the subscription has been renewed. I suppose I did not want this particular antivirus. I wanted to buy something else this year. So there was already a pre-filled checkbox, which I had not realized, which I had not seen. So what happens here is, if there are pre-filled, so this is this will be renewed yearly without, we will not take your permission again. So this will be renewed. All my credit card details are given there. So what happens in situations like this? I may not even realize, or I may have skipped this checkbox. I may have not done undone the checkbox. So in such circumstances, it is very detrimental to the consumer. So that is the reason why now it is mandatory that there should not be any such pre-filled checkboxes. Always the consumer should be allowed to read it and then checkbox that or tick the checkbox. So that is very important now. And they cannot manipulate on the price. They cannot put up an MRP which is high, a price which is higher than the MRP, and then say that we're giving you a deep discount, and yet the it's not even meeting the MRP requirement. So they have a lot of manipulation in the prices, which is not allowed as of now. So this is for the e-commerce entities. Going to the marketplace entity, why we are trying to give some specific detailing for each of these entities are because of their difference in the model, right? So when it comes to e-commerce marketplace, we have sellers and buyers on this platform. So we have to identify the issues and challenges in the marketplace entity. So they have given a specific, some specific, guidelines for these marketplace entities. So the very first thing that they have to do is to exercise due diligence. What is due diligence? How should we exercise due diligence? Due diligence, there is a specific provision under the Information Technology Act. You have to refer to the Information Technology Act Intermediary Guidelines Rules of 2010. So there they have something called due diligence, wherein the marketplace entity, along with all the other forms of intermediaries, they have to provide for terms and conditions and privacy policies on their platforms. It also mandates that they have to have grievance officers. So that part of the grievance officer has been brought under our e-commerce rules also today. But the most important thing is this due diligence will help us, identify, the terms and conditions on the platform. It tells you what is it that you should provide in the terms and conditions of your platform. Like you should put up a disclaimer. You should put a stop on your sellers from selling counterfeit products. So you have to mention very clearly, you have to mention it very explicitly on your terms and conditions that the seller should not be selling counterfeit products or fake products. So there are a few guidelines that they have provided of this sort, where the marketplace entities, all these marketplace entities will have to comply with. So that is important as far as due diligence is concerned. Now, the e-commerce rules also mandates that every e-commerce entity should get into specific agreements with vendors, with sellers. So they cannot have, that some of the sellers come in and some are given a privilege, some are not given. There's nothing of that sort now. Every seller who comes onto this platform, just the way we have checkbox for us, if you want to sign up with us, you have to agree to our terms and conditions. It's just the way the sellers will also have to get into agreements, specific agreements with the marketplace entities. So there they will also provide the sellers with certain details of what should be, what can and cannot be sold. When they sell their products, what are the details they have to provide? So all these things have to be mentioned in the vendor agreement. They have to also provide, the marketplace also now has to mandatorily provide details of the seller. So the seller details has to be provided very clearly on the platform. And they have to generate ticket numbers for tracking complaints. They have to provide adequate information as far as return, refund, exchange, warranty, guarantee, etc. are concerned. Details of payment modes, chargeback, all these have to be very, very clearly mentioned on their platforms. And the last one is very important, which I have highlighted. They have to maintain a record of relevant information, which allows for identification of sellers who have repeatedly offered goods and services which have been removed or access to which they have been previously disabled. Now, you must have been seeing a lot on various platforms that there were sellers who were selling counterfeit products, and we had sent a review saying that there is a product which is fake. So we send them reviews. Immediately, the e-commerce entity has to take action and blacklist these sellers or warn these sellers adequately. In the initial stages, they warn the sellers, but at the same time, they have to maintain that record of which of these sellers were selling fake products, or there have been complaints about these sellers. All that has to be very, very transparent given the e-commerce rules. So, and this is, again, I highlighted this point because this is very, very specific to marketplace entities, where we have sellers coming on the platform and selling it, reaching out to the consumers. So if there are sellers who are selling fake products or counterfeit products, it is the marketplace which has to keep a check. The next one is inventory-based models. So what happens in case of inventory-based models? Like I told you, I am going to be selling all of these products. So I don't have the seller, I don't have a third party coming to the platform. I have a direct connect with the consumer. So when it comes to inventory-based e-commerce entities, they have to also provide accurate information as far as return of goods, exchange, warranty, guarantee, delivery, shipment, etc. is concerned. The payment modes have to be specified. They have to also mention the total price in a single figure. So they cannot keep writing too many things. Like you see, at least 10 lines of only what the price is. So this less, that less, this, they cannot do all those things. They have to give total price in a single figure. No false representation as a consumer. Many a times what has happened when they start, now suppose I'm selling something on the social media or I have a website through which I'm selling. So just to attract the customers, I write some reviews myself as a consumer. So these kind of activities, unfair practices must be curbed. So that is one of the most important things which is for an inventory-based entity. So you cannot write your own feedbacks about your product and lure the consumers. So that should not be allowed. And no refusal to take back. You cannot say, I will not take back the goods. You have to and you have to provide appropriate refund and return or exchange aspects. Another important thing, suppose I buy certain products and I'm selling on the platform. And if I vouch for, or if I guarantee the authenticity of this product, if I say, buy this product, it is 100% assured or something like that. So in such circumstances, I have to bear the appropriate liability. If there is a liability, it can come on me also that I have made a statement of this sort as an inventory-based model. So this is again something very unique. That's why I have marked it in bold. It's very unique for the inventory-based entities. So this is something which the inventory-based entities will have to keep in mind. Then coming to the seller who's going to sell on this platform, there are some rules for the seller also. Number one, no false representation about itself as consumers, post reviews. This is something that even the sellers do. So they have identified this from part of the seller that they should not come up with any false representation as if they are consumers themselves. They cannot refuse or take back the goods or withdraw or discontinue services if they are, they cannot refuse to take back. So if they are deficient or defective or spurious, they cannot say, no, we will not take back the goods. A prior written contract with the respective e-commerce company. I told you about that. Actually, there are more details. It is much more in detail, which is provided under the e-commerce rules. You will have to read through it and understand what is it that should go in the seller or vendor agreement. Total price, they have also to provide that in figures, and sellers have to ensure that their product will have details of the country of origin. And then coming to accuracy in terms of information as far as exchange, return, refund, cost of shipping, etc. are concerned. And apart from this, delivery and shipment, guarantee, warranty, all of these have to be provided very explicitly by them as to who's going to bear all these things and who's going to be liable for the set of products. So these are some of the important things that the sellers will have to bear in mind. Again, what I have done through the 4 slides is I have only brought out the most salient features, for us to sort of understand what have been the reforms, what have been the main changes to strengthening the e-commerce, the consumer protection in e-commerce. So to just sum up the whole thing, I would say that the success of this whole CPA, especially in the e-commerce sector, would lie in, first of all, as far as consumers are concerned, creating education and awareness among the consumers. That is of very high priority. Second, as far as the business is concerned, they should also be made known, and there should be a lot of advocacy and trainings that should go out to them also about what should be their disclosures. The e-commerce rules is for them. It is for them to follow. So there has to be a lot of advocacy about disclosure norms. The third one, NGOs also have to play a very, very important role, both in terms of creating awareness among the consumers, also telling the businesses about what are these consumer protection rules. And for the dispute resolution machinery, we should try and explore contemporary ways, like we have the ODRs, which can be easy in terms of dispute resolutions. So these are some of the ways in which we can try and build a better e-commerce system, an ecosystem. The ecosystem is phenomenal. We've all been making great use of this. And as the years have been going by, I think all of us are sort of, we comprehend with this whole system, and we very much accept the system. The only thing is we've got to be safe. We've got to be aware of, the entire transaction. So this is something that we will need to do in the times to come. So just to share with you all, this is one of the books that I have come up with, which is on on e-commerce legal compliance. This provides an insight into close to about 70 enactments which touch upon some aspect of e-commerce, including consumer protection. So this is the book that I just wanted to share with you, and thank you all. I'm open to questions. I don't know, I may have finished within the timeline. I'm just checking it.
Yes,
yeah.
ma'am.
Dr. Sujata, I think I have finished my presentation.
Yes. Within the time schedule, you just winded up.
Yes. So, ma'am, we have a question from one of the participants. It is that if the shopkeeper has clearly specified that they do not have a return policy, then does they have a liability to provide the refund or not?
No, if the shop, you mean to say the regular store, or is it in the online space? This is exclusive to the online commerce, the e-commerce.
So I may ask the participant to clarify it.
Yes, we need
Yes, ma'am. Good afternoon, ma'am. It's for the online e-commerce, ma'am.
Yes, it's for the e-commerce. Now they cannot. First of all, they cannot come up with a statement saying that we will not take back goods. If the goods are defective, if there is deficiency, or if it is spurious, they have to take back the goods.
Okay, ma'am. Thank you,
They
ma'am.
cannot come up with a blanket statement saying that, or a standardized statement saying that there is no refund at all. They cannot come with such statements.
Ma'am, then we have another question that does online education institutions fall under the Consumer Protection Act 2019? Should they follow the grievance management and all the other aspects of the 2009 acts and rules?
Very good question. Yes, obviously, because education is a service, and whether you're providing it offline or online, it doesn't matter. So they definitely fall within the ambit of e-commerce. And every institution, every organization providing online services, online goods, selling, being in the online retail space, they have to follow all these rules.
Ma'am, can I ask a question?
Yes, please.
Ma'am, my name is Rajendra Singh. I'm speaking from Bombay, ma'am.
Yes.
You mentioned about 2019 Act and the grievance management, etc. As you know, there are companies like Urban Company or Urban Clap, Amazon, Upwork, etc. They are operating in India.
Yes.
Even today, they are not following the grievance management process, the grievance officer, the ticket number, etc., etc. So how can we proceed? That is one question, ma'am. The second question is, as per the current law, consumer law, is it okay to start an online entity in which, say, a big disease like a pervasive disease like diabetes is handled for consultation and prescription, etc., only through online mode, ma'am?
Okay, thanks for both these questions. Coming to your first question, where you mentioned about certain companies, right? You have picked on certain companies, but I wouldn't completely agree with it, because these are some of the top companies which have actually been in compliance. What is not happening is some of the small companies and some of the the startup companies where they do not know of these grievance redressal. But I think with Amazons and Flipkarts, they, as of what my knowledge goes, they have an excellent grievance redressal mechanism. So it's only for the startups and various small and mid-sized companies which are not aware of this. But if they do not have, then it is always good for us to write to them saying that you don't have a grievance officer. Please mention the grievance officer on your platform. That is one thing. The second question being, can a lot of these medical services be provided completely online? Well, my answer would be somewhere in between, where we'll also have to go with the medical council rules as to what is the extent to which they allow, online consultations. Of course, today we have a lot of them, but I think it is again limited to a certain extent, where they provide some basic consultation. Because of the COVID situation, every hospital has come up with this. I mean, they have their own consultations, e-consultations with their patients. But for new consultations, telemedicine and telemarketing, I'm sure there are certain rules which I'm not totally aware of, but we'll have to refer to the medical council standards and rules with respect to the entire consultation happening online.
Thank you, ma'am.
Thank you.
Ma'am, can I?
Yes.
See, this is regarding the e-filing. Can I ask a question about that?
I may not be the right person, sir, because I don't get it. I'm not a litigating lawyer. So e-filing of complaints with the forums, you mean to say, with the court?
Yes. The
I
2000.
am not the right person. I am not the right person.
Because this is 2019 allows the e-filing and other things.
Yes.
But the courts, already the commissions are not well equipped with even the staff infrastructure, and the president and the members is not available. In this scenario, how this could be possible in India and how much time it will take. So these are all the very concerns as far as ours is concerned. And you have mentioned that the e-commerce portals, they should have a grievance officer and other things. Why don't they apply for all these conditions to all commercial establishments too, not only for e-commerce? That is my concern.
Okay. Thanks for coming up with both these questions. As far as the e-filing is concerned, I will not be the right person to explain to you. However, yes, it will take some time, but I'm sure we will have the e-filing system well in place in some time to come. It's all happening, it's all evolving. So hopefully we will have a system in place very soon. The second, coming to your question, second question on why grievance officers only for e-commerce companies and why not for the regular offline stores or commercial establishment. My answer here would be the very nature of this e-commerce, where at any point in time we are not going to face the portal, or we are not going to meet anyone in the entire transaction. It is completely non-face-to-face, completely not human intervention at all. So given this situation, apart from having just an email address like info@abc.com or something like that, or customer care@abc.com, instead of having a one layer of grievance redressal, they are trying to build a second level of grievance redressal through these grievance officers. So if not at the customer level, you wrote to customer care@amazon.com. You did not get a response. So you have a second level within the mechanism itself where you can try to resolve your dispute through the grievance officers. So that way they will probably be able to help a lot of cases to be resolved within the internally itself before the case comes before the consumer courts or whatsoever. So that is the way I would look at it, sir.
Thank you, ma'am.
Ma'am, I guess you cleared all the doubts so well that there are no more doubts. Your explanation was so good. So, ma'am, Nitya, I would like you to conclude it.
Okay, Dharush. Thank you, ma'am, for throwing light on consumer protection, right? In this digitally driven world, e-commerce platform provide a plethora of opportunity, as rightly mentioned, should work along with respecting consumer protection right. It was a wonderful session with you, ma'am. We are elated to receive such an enriching insight. Thank you once again, ma'am.
Thank you so much. Thank you, Dr. Sujata Patil.
Pratima Madam, really it was a very, very, very insightful and very informative session. Even though it's your last session, but everyone were curious to eagerly waiting for your session. But your theme is quite interesting, and the way you put forth the information is really excellent, madam. Thank you for joining us. And this is first association with our university, but our association will keep continues in future also. Okay, thank you for coming.
Thank you, ma'am. And thank you, Professor Patil. I think Professor is also here, my teacher. So,
sir is there.
I don't
Thank
know.
you, Pratima Madam. Thank you.
Thank you,
for,
yes.
Good.
Patil sir, thank you, Pratima Madam. I hope Patil sir, you want to share anything on the stage, please?
No, what we see today morning, introducing the sessions. While introducing the sessions, I told about the resource persons and their expertise and what they are presenting. So whatever we expected, more than that, they presented and convinced the audience. For that, my sincere thanks from National Law School and on behalf of your university to all the resource persons, and also the people who are behind this particular webinar in your office, the technical people and other people. That is also very important to handle the webinar. So my sincere thanks to them and my team in Consumer Chair, Akshay, Vasvi, Komala. These people are also working hard to this program as well as future other programs. And here I want to share one information that on 24th evening, 5 to 7, the National Law School is organizing another webinar exclusively on online dispute resolution under CPA 2019. It is 2 hours. So the resource persons are the Justice Agarwal and Justice H.G. Ramesh of President Karnataka State Commission, and myself. 3 people will be there to share only on online dispute resolution, nothing more than that. So if you are free on that day, kindly come online and listen to the daily discussion And if you have any queries on that, you can ask and we will clarify. So with this, my sincere thanks to everybody. Once again, thank you very much.
Yes, sir. Thank you. Thank you very much. Now, from our end, I hope, Tarush, Mudra madam.
Yes, ma'am. Just a second.
Yes, ma'am. Ma'am, around 350 people successfully have across the country have enthusiastically enrolled for this webinar in with Navaratna University and NLU Bangalore, and we are overwhelmed by the response. We expect your enthusiastic contribution towards our upcoming international conference on law and technology to be held on 30th January. I will be attaching the link in the chat box. Now I would request Naveen Sinha, sir, the professor at School of Law, Navaratna University, to give the vote of thanks.
Okay, thank you. Tarush, can you hear me?
Yes,
Am I
sir,
audible?
you are audible.
Okay, so as we enter the last stage of the webinar, and as Tarush just pointed out, I'd like to believe that today's webinar was a success, not only in terms of the turnout we had, but also in respect of the insightful discussion we had on what I believe is one of the most sought after but misunderstood laws of all time. For this, I cannot withstand myself from thanking the speakers, even though I have to thank them again in the vote of thanks. So before that, I'd like to give a summary of today's proceedings. We had Justice R.K. Agarwal, President of the National Consumer Disputes Redressal Commission. Justice Agarwal highlighted the importance of consumer protection and argued how, in the face of modern technological advancements, the 1986 Act has failed to meet the expectations of the consumers. So, highlighting how the new legislation is broad enough to effectively tackle all the challenges, Justice Agrawal argued that the present legislation marks a movement from caveat emptor to caveat venedictor. We also had Honorable Dr. S.M. Kanitkar, member of the National Consumer Dispute Redressal Commission, and being an expert in the field of medical negligence, sir also pointed out, analyzed rather the meaning of different terms, especially standard of care, proximate cause, and standard care in the context of medical negligence. We also have actually Dr. Ashok Patil, chair on consumer law practice, law and practice at National Law School, Bangalore. I'd like to say that with Dr. Patil's unique vantage point in terms of his experience in working with the drafting of the present legislation, we had a lot to learn from him in with regard to the efficacy of the present legislation. And honestly speaking, sir did not, disappoint us. Sir actually highlighted on the background of the CPA 2009, identifying the deficiencies of the previous legislation and rectifying it. He also gives some empirical data to show how consumer right awareness has moved forward in the country. We also had Dr. Pratima. We have actually Pratima Narayan, advocate, founder, partner, Teki Law Logi Consulting LLP, Bangalore. Madam gave us an overview of the e-commerce regime in India and consumer complaints. She also talked about the need for consumer protection reforms and why the old law was not able or not consistent with the needs of modern digital technology and larger consumer base. We also had Mr. Jaideep Verma, advocate, founder, Jaideep Verma Associates. So basically highlighted on the need for change and the need of an effective framework, legal framework for consumer protection. And he expressed hope that the relationship between the consumer and the right not to be exploited would be, taken care of by the present law. So as I come to the end of the webinar, I'd like to express my heartfelt gratitude on behalf of the management, the School of Law, Business and Law, Navaratna University. I'd like to express my heartfelt gratitude to Justice R.K. Agrawal, President of the National Consumer Disputes Redressal Commission. I'd also like to express my heartfelt gratitude to Honorable Dr. S.M. Kanitkar, Member of National Consumer Dispute Redressal Commission. We had Professor Neela Yagnik with us, Provost Navaratna University. I'd also like to express my heartfelt gratitude to Professor Neela Yagnik. At the same time, we had Dr. Ashok Patil, Chair Professor, Chair on Consumer Law and Practice. It has been a wonderful help on your part, and without you, this program would not have been possible. So, a very, 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 heartfelt gratitude to you as well. We had Dr. Pratima Narayan, advocate. Madam, it was actually, we had a very engaging conversation on this topic, and thank you for taking out the time to be part of this webinar. We also had Mr. Jaideep Verma, advocate. Once again, I'd like to thank Jaideep Verma for the time taken in this regard. We had Dr. Professor Hitesh Bhatia, Professor Head of School Business and Law, Professor Dr. Sujata Patel, Principal Law Program, SBL, Dr. Dinesh Panchal, colleagues, faculty, students, and participants. Thank you very much for being a part of this wonderful program. Thank you very much. So Tarush, this is for you.
Thank you. Thank you. Yeah.
Thank you, ma'am. I would also like to thank all the speakers, dignitary, and the participants. Each certificate shall be forwarded to all the participants within the 15 days. Hereby, Sujata ma'am, if you have anything to say.
Oh, nothing. Thank you, sir. Thank you, Patil sir. Thank you, Pratima madam. Thank you, one and all, and thank you all the participants, students, faculty, colleagues. Without you, I think we could not have this today, and we had a great day and a great informative session. Thank you, one and all.
I formally declare the end of the national webinar.